Hello, everybody. Hello, everybody. Welcome to the live. Welcome to the live. Thank you for tuning in. Hello to the playback crew. We'll see how many people we can get in here in the first few minutes because we've got some motions to discuss and a little bit of news. There was a filing today from the prosecutors responding to Brian Steele's motion asking the judge to reconsider her rule. Judge Krause's ruling on the ex parte, so we can get into that. But we've got Doug Weinstein here, who some of you know from previous interviews. He represents Deamonte Kendrick, who is Yak Gotti, the rapper signed to the Young Stoner Life label with Young Thug. And he's here to discuss some of the new motions with us and his reactions, including the request for a gag order, which we talked about yesterday. Prosecutors have filed that, complaining about some of the interviews that they've done with Sylvia and the account I'm Not a Lawyer, But, and then yours truly. So, Doug, thank you so much for joining us this afternoon. I did see your response on Twitter a few minutes ago where you said that you have a duty to represent your client who's a public figure and that he's been smeared by prosecutors. And is that can we expect to see an argument like that in a filing that responds to this gag order request? Is that the defense here?
Yeah, and just to be clear, I don't think I used the word smeared by the prosecutors, but I think I said that his reputation has been tarnished by the state. Just, I don't know if that makes a huge difference, but first off, I should start by telling ADA Love and Hilton hello. How are you guys doing? So I guess y'all are watching me now, and maybe have always been. So how are we going to respond? Well, it's pretty simple. Just look at the rule that the state cited in their motion, Rule 3.6. And I'm permitted under that to comment on information that is in the public domain. And so my comments have been limited to those things that have been filed publicly, that have taken place in the courtroom. It's unlike, maybe not as the state wishes, but this is a public trial. The witnesses, all the proceedings have been streamed out to the public. The courtroom has been open. I know that the state has repeatedly wished that some of the witnesses not be put on video. And for the most part, they've gotten their way on that. But I think this is just part of the pattern of the state not wanting the public to see what's happening in there. And yeah, I have the absolute right and obligation to speak out. My client's a public figure. He has a career as a singer, as an artist, as a writer. And I have a duty to him to not only advocate for him in the classroom, but to advocate for him in the public arena.
And it seems like their reading of the Georgia rules of professional conduct. I mean, when I'm reading this, I'm like, does their interpretation of this allow for any public comment whatsoever? The comments that they cited seem to be criticisms of them and then proclamations from the defense that their clients are innocent. But that seems to be stuff that we hear about in cases, in high profile cases.
Yeah, and we're absolutely under Rule 3.6 allowed to do that. And it wouldn't be the first time that they have put forth an argument that I believe doesn't have merit. So I'm happy to file a response and swat this away. But unless, of course, I'll do whatever the court orders. Let me make that clear.
Yeah.
But I don't believe that this court, or any court, would rule in their favor on this, or will rule in their favor. So I don't anticipate being gagged in any way by this judge. I mean, I was looking back in Georgia, like there was a gag order in the Ahmaud Arbery case, but that was a very different situation, if you remember, Meghann. I mean, did you look at that gag order?
No, I haven't seen the gag order. I'm familiar with the basics of that case, but what do you see as the big differences that led to the gag order there?
Sure. In that case, that was an order that took place before the trial commenced. So you had obviously potential jurors that were out there that could be seeing the statements. And in this case, our jury is impaneled. And they are under a directive from the judge to not consume any information about this case, to not talk about this case. And Chief Judge Glanville always did a great job at the end of, I think, every day, giving the jury, and you guys have seen it, he gives the jury the directives on what they're allowed to do, what they're not allowed to do. And so we have to presume that the jurors are following the instructions of the judge. So they shouldn't be consuming any of this in any way. So I don't think any statements I make are prejudicing this trial at all. All I'm doing is educating the public on what's happening in that courtroom.
Right. Right. I did see just through a quick Google search that there was a gag order issued in the RICO case involving the Cop City protesters. Is that do you see differences between that case and this case, or just what they're doing, or were they weren't like 19 months into trial when that gag order was issued?
Yeah, and I haven't seen that gag order. I mean, obviously, I'm Suri Chada Jimenez is a colleague of mine, and I believe he's under that gag order. And I haven't been following Cop City that much, but I do know they haven't gone to trial yet. So I haven't read the order, but that's a major difference, because that's a situation, again, like Ahmaud Arbery, where you've got potential jurors that would be out there consuming media. Our jurors are not doing that. They're instructed not to do that. They've been impaneled. No, they're not sequestered, but they are under instructions to not look at any of this.
And it seems like if it, for some reason, the jurors did see those statements, we have a much bigger problem in our hands than just the defense attorneys need to stop talking. It would mean that jurors were in violation of this order, correct? I mean, there's some argument that a gag order like this in the middle of trial kind of undermines the integrity of the jury, because it almost kind of assumes or worries that the jury is violating their oath not to look at this stuff.
Well, I would just say it's unnecessary at this point for there to be a gag order, given the orders that the jury is under. And our jurors seem to be very conscientious. You know, I know that in whenever I filed the order to try to get this trial moving, filed the motion. I wish it would have been an order in late March or early April to try to get this trial moving along and to eliminate redundant witnesses. I was concerned that the jury would lose focus as this trial dragged on. And I cited a bunch of studies in that motion and to the judge, showing that jurors kind of lose focus after 10 or 20 days of trial. And of course, we're past day 100. But when I look at them over there, for the most part, they're paying attention, they're taking notes. So I think that they would be following the judge's admonitions. I think that's what Judge Glanville would always call them, his admonitions.
Yes. Yeah. And one, I mean, just in my experience, I've had attorneys tell me that, they think all jurors violate that. But a clerk I know who worked in state courts for a number of years and then federal courts, and she's the one who actually deals with the jury every day, talks to them. She thinks they actually take that pretty seriously, and that if one of them does violate it and the other people find out, they all kind of rat each other out. But then another way to look at it is, if you were sitting all day in a jury in a case like that, would you want to go spend your time off reading more about the case and thinking more about the case? Maybe you don't.
Yeah, in my experience, I think they would be eager to get home and think about anything else than what they've had to watch for the last day.
How saturated is the news, though? I mean, just being in California, we don't see it on the local news, but it's on the local news every night in Atlanta, right? Just a trial update, and then especially more coverage in the last few weeks.
Yeah, it's interesting, and I'm not a big consumer of local news. I read the AJC. I don't really watch much, but just from reporters reaching out to me, for a time, there was a lot of interest when the case began, opening arguments, and there was certain witnesses. There's more interest. I think with Kenneth Copeland, there was more interest, but the media kind of went away for a while. But yeah, they're back again. So, with all the motions with Judge Glanville being recused, it's in the news a lot. So I think for a juror, I imagine the jurors are probably just avoiding any kind of local news consumption. I think it's the only way to really avoid this.
Yeah. So with 6 defense attorneys, how do you decide who's going to respond to the prosecution motions? I know of 2, the gag order request and then also the request regarding supposed character evidence regarding Donovan Thomas. Is that, how do you folks decide? Are you all going to file a response to the gag order request, or is it just one?
That's a great question. I have not discussed that with the other defense attorneys. I mean, I was singled out in it, so I'm certainly going to be filing a response to that. I would imagine the others that were singled out will be filing a response, but honestly, I haven't talked to them about that.
Yeah, yeah. And so yesterday you filed the motion for mistrial and also a bail request for Deamonte Kendrick? Are
That's
those
correct.
your 2 motions you have pending right now?
That's right.
And the mistrial is along with some other mistrial requests, but it specifically says makes the double jeopardy argument, correct? And that's important for people watching at home. A double jeopardy finding would mean that they can't be retried again. So that's your ultimate hope, right?
My ultimate hope. Although in this motion, I'm more laying the groundwork for factual findings that would support a later argument for double jeopardy. I'm not specifically requesting the court to find mistrial and effectively a plea in bar, as we would call it in Georgia, to bar further another trial in double jeopardy. Kind of taking everything a step at a time. So
Yeah.
we got the mistrial. I'm sorry, we got the recusal, which was warranted based on those things I mentioned in my motion for mistrial. I'm hoping that we get a mistrial. And I believe that really the basis for the mistrial should be our being goaded into it. I think and I say this, of course, I repeat it in the motion over and over again. It's a bit of a theme, I think. But we're winning the case right now. I think Max Sharp has said the same thing. We're winning, and he says it very explicitly in his motion. I think mine was more like the state is losing, and they've goaded us into a mistrial so they can restart. I think Max just came right out and said we're winning, and I do think we're winning.
Right, because Max's motion it's a motion for fair and constitutional trial, much like Brian Steele filed a few weeks ago, and I think that's still technically pending, right? But he makes the argument that starting over really isn't in Shannon Stillwell's best interest. And so, I mean, he doesn't want a mistrial unless there's a double jeopardy finding. Is that one advantage of having so many defense attorneys working on a case? He can feel comfortable making that motion himself because there are other mistrial motions pending. So if there is a mistrial with double jeopardy, it'll attach to him too.
I think one clear advantage to having multiple defendants in a case, I mean, of course, there's disadvantages too, but one clear advantage is that we can take different approaches to things. And this isn't some kind of coordinated, I mean, I wish it was that well coordinated. This isn't a coordinated, hey, we're going to take different avenues of attack. But you do have different approaches to this mistrial. So, Max's seems to be, I want a mistrial, but only if we can get it with double jeopardy attaching. And in fairness, that's probably what we should get. This case is so messed up at this point for so many different reasons. I mean, I was struggling to decide how I was going to approach this motion for mistrial because there's so many different grounds that we could look at. But just in my, I guess it's my philosophy that I try to do things in a narrower, more focused manner. I don't want to overwhelm the judge with here are 12 reasons we should have a mistrial. And by the way, if you look at like Bruce Harvey's motion, I don't think his is that way. I don't think his is here's 9 reasons we should have a mistrial. His is more like there's no way a judge can parachute into this case and even attempt to conduct a fair trial going forward. And here are the 8 or 9 reasons why a judge can't be dropped into this case and just continue. And I agree with Bruce as well. All of these are valid reasons for a mistrial.
Yeah, I found Bruce is so persuasive, and part of it is just the situation itself for any judge, but then a lot of the Glanville's own rulings and his own statements throughout trial saying, oh, well, we can revisit that later, and he would always say that. So it seems like those statements right there kind of justify it. But I saw somebody asked, we kind of touched on this, but Antonio Lee asked if this is the strongest mistrial motion you filed. It seems like it's the one with the most going on.
I mean, I think this is the strongest. This is the most egregious violation of a defendant's rights I've seen. So in that sense, I would say it's the strongest mistrial motion. They're just those three reasons that I cite in the motion, I think are any one of them would be more than sufficient to grant us a mistrial.
And then Jeffrey asked if the mistrial, when the mistrial gets denied, does it get immediately appealed and stay the proceeding, or would that involve Judge Whitaker actually issuing a stay? Would she have to issue a stay so you can appeal it?
Yeah, I don't believe that it would immediately trigger a stay and an appeal. I believe that we would need a certificate of immediate review. And then she would have to order some type of a stay of the case. I think. Don't hold me to that. But we plan on winning this. But I think I need a certificate of immediate review if she denies it. And I don't know if she would grant that certificate.
Yeah, it's going to be. I mean, she seemed to really be taking a full steam ahead approach at the last meeting. I mean, when I was reading Bruce Harvey's motion, I was like, I'm completely persuaded that there should be a mistrial. But I just remind yourself that she knew all this going into the status conference, and she took that kind of let's go forward attitude. And I mean, Bruce even quotes her in there saying that she's not going to go back and review all that stuff. It's like, okay, well, how can you make informed decisions going forward? But
well, think about it. How can she review it? She doesn't have a transcript to review.
Yeah.
I mean, there's over 100 days of testimony. There's all of these rulings, but even the 100 days of testimony, you go back and watch the YouTube videos. It's not practical. Yeah, I thought Bruce's motion was terribly persuasive.
Yeah. And somebody points out, and I think, I think we just lost Doug here. Hopefully, there we go. Hopefully, there we go. Somebody asked, I think Thugger Daily posted this. The Adrian Love pointing out the recusal that Judge Whitaker had recused herself like 6 years ago from a case involving Young Thug's brother, because when she was in the DA's office, she worked on an appeal involving that case. And it sounds like the prosecutors were basically just pointing this out. They weren't asking for any action on it. Is that what's the reason for that? Does the defense have any kind of response to that, or they?
I don't know, because I haven't gotten to research that issue, so I can't really speak intelligently to it yet. I don't know where they're going with that.
Yeah, I mean, you could almost take it as, is that some kind of warning to Judge Whitaker? But it seems like if they wanted her to get off the case and thought they had a case for recusal, they would just ask to get her recused. So
yeah, I would think that if they believed that merited recusal, that they would have a duty to file that motion and seek that recusal.
Yeah, and then this question gets into really a pretty big motion from Brian Steele, and you touch on this in your mistrial motion too, that Judge Krause ruled that she said she generally agreed with Judge Glanville's assessment of the ex parte, and really her reason for recusing Judge Glanville had nothing to do with that. It was all about how he defended himself against these recusal motions. So one motion that Judge Whitaker needs to decide from Young Thug's lawyer, Brian Steele, is he wants Judge Whitaker to take back those findings from Judge Krause and say that the ex parte was illegal. Did you ask for that up front in your mistrial motion, or is it the mistrial motion kind of depends on that, right?
I don't want to say it depends on it, because I gave three bases for the mistrial. And so I would say perhaps one of those bases depends on the judge seeing the ex parte, just the holding of the ex parte meeting as improper. But I also say that the conduct of the judge in the course of the ex parte proceeding was not proper. And I believe maybe Judge Krause in her ruling would not have agreed with that. So I do need that to be altered. And it's implicit, I think, in the motion. that I filed, and it'll have to be made explicit when I argue it. But
Yeah.
also, if you put everything having to do with the ex parte proceeding aside, I mean, just set it aside. The third grounds I had was that Chief Judge Glanville didn't follow Rule 25. And after I filed my motion for recusal on June the 12th, he didn't stop all proceedings and refer it out. So we heard another 3.5 days of testimony from Copeland. And according to Georgia law, all of that is void. And so another basis for my mistrial is the inability to unring that bell, for the jury to unhear that testimony.
Is there any chance that, is the judge going to come out next week and try to argue that what's the big deal with Woody's testimony? Like, could you envision that being any kind of legal argument against this? Because everything that I've read and everything I've heard seems it's pretty cut and dry that this does need to be rewound, that some of it is going to be invalid. So is there any chance the judge could try to argue that it doesn't? I mean, is there any history of that?
I mean, the case, I think anyone that argues against this would be going against the case law, because the case law in Georgia is pretty cut and dry, that everything after that, all the formalities of seeking recusal were met, which was June 12th. And the judge, it had to be stopped then.
Yeah.
So I don't know how you say, maybe you say, well, I don't want to work on their side. I mean, you say harmless error. But
yeah. It's a pretty big witness.
It's the witness. It's the witness against my client. He is the witness.
Yeah.
And that's why I think it was so disturbing that this happened, that the ex parte meeting happened, that we were not permitted to participate, that the judge coerced. And it's clear. I mean, read the transcript. Mm-hmm. The judge coerced Copeland into changing his mind. And there's plenty of case law in Georgia that says a judge cannot do that. I've got that Webb case from the Supreme Court, and its lineage that says it's a little bit reversed. It says that a judge cannot intimidate a defense witness into not testifying. But if you get into the logic of that, that's not dissimilar from a judge coercing a prosecution witness to testify. Or at least I think so. So anyway, I think even if Judge Whitaker does not find the ex parte to be improper, I think the coercion and then the continuing with the trial was improper. And again, everything I'm telling you is in the pleadings.
Yeah. Yeah. What about, I know there are a lot of questions about what's currently going on with Woody. I mean, he's been embracing his social media stardom and creating accounts, doing interviews. He's available for bookings. I mean, as a journalist, I've just kind of ignored it because I don't see it as being directly relevant to the case. And I mean, there's no gag order on him. I mean, it seems like he's free to do whatever he wants, but can we expect this to come up in trial? Is it going to be an issue that he's talking to people?
Well, I think it's relevant to me in the sense that the state has been painting our clients as intimidating witnesses repeatedly. The questions they're asking them in front of the jury, basically they are implying that the witnesses' stories are changing. The reason the state has to consistently impeach their own witnesses is because some type of intimidation by our clients. The witnesses are afraid of us. I don't think Mr. Copeland looks afraid of us. Does he look afraid that, he's live Instagramming his whereabouts? Yeah. I don't think he's afraid somebody's going to come after him.
No,
or at least not us. He seems more concerned about the state locking him up.
So it seems like if we're going to be hearing about Woody's, newfound public persona, it's more likely to come in the cross-examination because, like you said, it lends into this, are you really being intimidated? I mean, it'll be interesting to see if the prosecutors bring it up because when you kind of put it that way, it's like, does it really benefit their case to let the jury know that, Woody now has 300,000 followers on TikTok or whatever it is?
Yeah, there's a lot of complicated issues we're going to have to deal with going forward. We're going to have to explain to the jury what happened to the judge.
Yes. and how, I mean, just when I was looking at, changing judges midstream, California has a policy that says if a judge, as Brian Steele would say, God forbid, if a judge dies or has a health problem in the middle of the proceeding, it's like a written policy about how this can continue. A judge can take over the trial. But when you read this policy from 1997, they were thinking about misdemeanor cases, DUI cases, not some 19-month complex RICO trial, right? Does Georgia have a policy like that regarding health problems with judges?
I don't believe so. This whole situation is, in some sense, sui generis, right? It's unusual. If you look at everything about, for example, recusal, it's not, because trials are usually a few days, a week, maybe 2 weeks.
Yeah.
It's not anticipated that a judge will be recused in the midst of trial. It does happen at times around the country. I was searching everywhere for cases. I found some up in Chicago. It's just very unusual. They usually result in a mistrial. Actually, I haven't found one where they haven't resulted in a mistrial. And sometimes they result in double jeopardy. It depends on, sometimes double jeopardy attack. It depends on the reason for the recusal. But I think the best policy is to tell the jury the truth.
Yeah. Would that be, and to just say that the judge was recused from the case? Or, it seems like in all the cases that I've covered, they would want to just say, there's been a change with the judge. You're not supposed to read anything to it one way or the other against the defense or the prosecutors.
Yeah, I haven't fully formulated my my ideas on that yet about how exactly we should approach that with the jury. I know that we should be truthful, and the degree of information we relay to them, I'm still thinking about.
Yeah.
At least my position. It's ultimately up to the judge, but
yeah.
Because here's the thing, Judge Glanville's a witness in this case.
Yes.
He's been named by Brian Steele as a witness. ADA Hilton's a witness. ADA Love is a witness. That's going to have to be explained to the jury.
And that gets into their motion. There's still a pending motion from Brian Steele to recuse DA Hilton and DA Love, right? That's currently pending. We can expect a response from the prosecutors on Friday, I think.
That's what the judge has ordered. If I heard the judge properly, and I think I did, the judge said all motions must have been filed by yesterday, and all responses are due this Friday. So I would have expected the state to put all their motions in yesterday, if you're going to follow the judge's orders, and then our responses are due Friday. So their responses are due Friday, our responses are due Friday.
And then it's Tuesday morning that this all starts. And I know you can't make any predictions, but I was thinking, I'm so interested in this right now that for a long time, I felt like this trial, while it's so important and fun, fun might not be the right word, but the testimony was really engaging, like Trontavious Stevens. Legally, it felt like kind of a dud of a case because it wasn't a real RICO case. The prosecutors were in way over their head. Glanville was in way over his head. But this unprecedented judge recusal and the moving in of a new judge in the middle of trial has given it this whole legal intrigue now that I think is really interesting, could really interest people in the legal community, down to what's the first motion that the judge is going to deal with on Tuesday? Does she deal with the mistrial motions first, or what would your preference be?
I don't know about preference, but I'll talk about what I think is legal reality or practicality. I don't see how you don't address Brian Steele's recusal of the prosecutors right off the bat, because if that is warranted, shouldn't it be done before they start arguing these other motions? That's how I would look at it,
because that would basically end it right there.
And I'm not speaking. I don't want to speak for Brian. I don't know what his position is, but just looking at it, I'm dying to get in and argue my mistrial. I'd love to Tuesday morning just go into it, but it seems to me as a threshold matter, you have to decide whether these prosecutors can continue in their role in this case.
So ideally, the order, would the first motion to build a foundation for that, would it be best to hear the motion to rescind Judge Krause's finding about the propriety of the ex parte ruling? Because if for some reason Judge Whitaker is willing to say that that ex parte was improper, that lays the foundation to get rid of the prosecutors, right?
Yeah, I mean, I guess that's a great question. I don't know. I think you could do the prosecutors first, and then you could get, because I think what I don't know.
Well, because the argument is even without a finding that that ex parte was improper, that doesn't change the argument that they're still witnesses in the case, right?
That's right. That's right.
Okay, and that's the recusal for them.
Because this gets into the credibility of Mr. Copeland. It gets into a lot of issues. I think it's important that the prosecutors get up there and that Brian examine them on, what they did in that meeting. And again, it's not necessarily about the meeting. It goes to the credibility of Copeland when he's on the stand and what he's testifying to after he's been, bullied into testifying.
Yeah.
Because this is a man that he has admitted on the stand repeatedly that he lies. He lies to avoid going to jail. He seems to be. I just look at his words. I don't need to repeat his words.
Yeah.
And he seems to testify that, these are my words and not his, but he seems to sprinkle grains of truth in the stories he makes up to law enforcement to give them credibility. Yeah.
And it seems like for people who are catching up, we're going over the motions that were filed. They're going to be dealt with on next Tuesday. The big one that got a lot of attention is a request for a gag order. But I was saying yesterday that one that seems really substantive, and it's the first test of whether Judge Whitaker is willing to change rulings that Judge Glanville made, is the one regarding the hearsay statements of Garlington that they want to ask Copeland about. And for people catching up, the 2015 interview with Kenneth Copeland, one of his 2015 interviews, he said that Shannon Stillwell and Deamonte Garlington got into a car with him after Donovan Thomas's murder and basically confessed that little D said something that was akin to a confession. But as we all know, Woody has not backed up anything he said on the stand. So now prosecutors want to bring in that statement from him and ask him about it. But there was a whole debate about it being hearsay and not admissible. And now it sounds like there's a hope from the defense that they can get that ruling changed and prosecutors won't be able to bring it up. Did I?
Yeah, I think you've summed that up nicely. I mean, the big issue is that these statements were admitted by Judge Glanville as statements of a co-conspirator. But if you look at that hearsay exception, those statements have to be in furtherance of the conspiracy.
Yes.
And that language appeared to be read out by the judge when he was making his rulings, or ignored, to me at least. Of course, I'm biased, but he didn't seem to pay attention to that aspect of the hearsay exception. And there's clear case law in Georgia that mere spilling the beans, telling people someone after the fact, that's not a statement of co-conspirator that can come in. That doesn't work under the hearsay exception. So there's a lot of rulings that I'm sure both sides would like to revisit. I think this judge is reluctant to revisit some of those, but I think when you've got, when you have clear error, what I think is clear error, how can the judge ignore that going forward?
And especially with this ruling, while this ruling was made, it hasn't been implemented yet, right? We have not, the jury hasn't come back, and Copeland, these statements haven't been played for Copeland. So there's definitely room for her to change.
That's true. Okay. There's still time to fix this.
Okay.
If the case proceeds.
It looks like somebody was Tasha Kendrick. Is this Deamonte's mother or his?
This is Deamonte's mother. Hi, Tasha. Tasha, okay. Who's in the courtroom pretty much every day. She's an amazing supporter of her son.
That's great.
And I really, but Tasha does a lot of working at night and then coming into court all day. So I don't know how she's even functional, but she's fantastic.
That's awesome. And I think that's one forgotten aspect of the case, because and just watching it on the live stream, we don't really even see the gallery very much at all. But yeah, I mean, these people have family members that want to see them and want to follow the case, and just the exhaustion of having to go to the courthouse every day, it just must be totally different. But
well, it's massive stress. It's massive stress because
Yeah.
you're not only exhausted because you're working at night or evenings and then going to court during the day, but your son is on trial.
Yeah. Well, is there some thought that, I mean, for Mrs. Kendrick and then just for the attorneys, that there's going to be some relief that you no longer have a judge saying, let's just see where the day leads us? Yeah, it sounds like you're going to have a set end time, hopefully. I mean, as it can be.
I am thrilled with the idea of starting at 8:45 sharp every morning, and going as long as if the jury's comfortable going to 6, I'm all for it. I mean, I'm the one that basically complained about this trial dragging on too long. So the only reasonable position that I could have is, yes, thank God, let's move this forward. Because if this case is not going to result in a mistrial, let's get it in the hands of a jury as soon as possible and get my client out of jail.
Well, it sounds like, I mean, we were averaging maybe 2 to 2.5 hours of testimony a day, maybe 3. I mean, it seemed like with all the comfort breaks, there's a federal judge in LA that's a little crazy, but he gets like 5.5 to 5 to 6 hours of testimony in a day because he starts at 8 and he goes to 2 or 2:30 and he doesn't take a lunch and he only takes 2 10-minute breaks. And that's a little crazy, but hopefully we don't have quite like that.
Don't give Chief Judge Glanville too much grief about the number of breaks. If you want to give him some grief on the length of breaks, I won't defend that. But he was giving breaks. A lot of it was because of my medical issues, that he would give me a break every once in a while. I didn't need 45 minutes, maybe 5, but I think he was doing that. I mean, also, it's just like I've told you before. It's very, very taxing in there. I don't know, but I'm fine with let's put this on speed and let's get through this. And I was really glad to hear Judge Whitaker say that when she sees a witness who is redundant, she's gonna, she has the power to eliminate that witness, which is what I requested of Judge Glanville back in April.
Yeah, because I know we talked about this before, and I kind of wondered out loud. I'm like, all the comfort breaks and just how obnoxious the schedule is. I was kind of wondering, does it help the defense to have the prosecution's case so jumbled like that? But you had said that you really think it really benefits both sides to have the case streamlined. But with you guys thinking you already have the advantage, having it streamlined obviously you think it has way more benefits than possible.
Yeah. Again, I mean, Deamonte Kendrick is locked up in Rice Street, one of the worst jails in the country. Probably only Rikers Island is worse. And I don't even know that for sure. I do not want him in there one day longer than he has to be. Yeah. Period.
And that brings us to the bail motions. There's bail motions pending. The arguments, of course, are the arguments made under Judge Glanville, but you feel like there's new circumstances that warrant the reconsideration from the new judge.
Certainly, because it's been I think the last time I asked for bond was, I don't know, 14 or 15 months ago now. So the situation has changed. The trial is not moved with any kind of expediency. And I think the grounds, the basis for giving him bond is still just as valid today as it was a year ago. I mean, look, when we first asked for bond, the state, 2 years ago, 2+ years ago, the state got up there and talked about how dangerous all these guys were. They were a threat, all of them, like all 28 or however many were locked up at the time.
Yeah.
How dangerous they all were. This is, again, public information. It's out there what they argued. And then how many of them pled out within about 6 months and are back on the street? I mean, if they're so dangerous that they couldn't get bond, then why are you releasing them on the street? So I just don't think the state has credibility. And so I know when they argued last time, they mentioned a couple of incidents in the jail, which are all crap. And I'm not representing Deamonte Kendrick in those, but I think they're all going to be resolved in his favor. Anyway, that's what they brought up. And again, that's just... Anyway, if you look at the Ayala factors, the Georgia factors for bond, I still believe that he merits bond. All these guys merit bond, but I'm not their attorneys.
So we can expect those to be dealt with next week. Like, and we can't make any predictions on what order the judge is going to take these in. But have you penciled out all of next week? Should we expect this to be Tuesday, Wednesday, Thursday, Friday, or?
I expect Tuesday through Friday to be fully booked with this, and I just hope we can get through all the motions next week.
Right, because she was saying the jury was scheduled to be off next week anyway, but she had said something about we'll see if we can call them back in August 5th or August 12th. But that also just seemed to be kind of the opening day, narrative for her that she's trying to push forward, because she had not dealt with any of these arguments for mistrial yet.
That's
so
right.
You're hoping that you can change your mind.
Yeah.
So.
And I think the bond motion should go after the mistrial motion, because that could affect that.
Yes.
If we get a mistrial, I just don't see any. There's zero reason he should not continue to remain in jail. He shouldn't be there anyway, but certainly not if there's a mistrial.
And that's if there's a mistrial with no double jeopardy attached, because it sounds like you'll take that mistrial anyway, but then you're hoping that really warrants the release. Whereas obviously if there was a mistrial finding with double jeopardy attached, they would all be released because there'd be no more charges anymore.
I would think so, yeah. But we have to take everything a step at a time, and that's what we'll do.
Because I'm seeing some questions in the chat about if there is a mistrial, what are the chances that they retry it? And I think the chances are pretty great, which is why you're hoping for the double jeopardy finding that would prevent.
I have to tell you, people I talk to, criminal defense lawyers in Georgia, folks that have been practicing for a long time, everyone's all over the map as to what they think the DA's office will do if there's a mistrial. So I don't even begin to guess what they're going to do.
Is there an election in November? Is Fani Willis up for re-election?
There is, but she won the Democratic primary, so I don't expect. I think she's in.
Because I was wondering if the YSL trial is a political issue at all, but it sounds like there's no chance that whoever her opponent is right now isn't going to win. So
I think the Trump trial and the YSL, to some degree, maybe the YSL trial could have. I mean, it's more the Trump trial that was an issue in her primary.
Yeah.
But having pretty much sailed through that primary, I'm sure she's all set for re-election.
Yeah. Well, what else should people know going forward for people who are just joining? We were talking about all the motions that have been filed, and there are the basics: the mistrial and the bail motion. But the one that caught some headlines is the gag order request. But
yeah, I think the big thing is just to watch on Friday when both sides' responses drop, because then you'll have more to talk about. But I wouldn't expect any more motions to be filed today, tomorrow, because the judge pretty clearly said they had to be filed yesterday.
Yes.
So I would think if anyone tried to file a motion today, that would be improper and against the judge's order.
Yeah. Well, okay. Well, thanks so much.
I'm going to scoot out and go see a Braves game.
Okay, great. Well, hey, have so much fun.
Thank you.
Yeah, I'll see you later. Thank you so much.
You guys take care. Thank you for having me on, Meghann. And again, thanks for covering the trial and all your great questions.
Absolutely.
I don't mean
All right. What's up, all? One second here. What's up, guys? Just had to drink some water there. Have a tendency to like let my voice go during these lives. Talk a little too much. But yeah, I've got Boosie's lawyer. I know her from a bunch of other cases, but she's gonna come on in here in a second, and actually in like 14 minutes. But I see people saying he was re-indicted. No, he wasn't. His case is still dropped. But she can talk to us about that. But yeah, that was cool. I couldn't talk there for a little bit. Had to clear my throat. But Tasha, it's cool to see you in the comments like that. I admire your strength, having to deal with your son locked up like that and going to court every day, and just the stress of it all. Hopefully the new judge helps speed things along and just like kind of takes the stress out of it, although the whole process is just inherently stressful. But hopefully the new judge is a blessing for you. But yeah, Rice Street does sound like just terrible. I mean, all the jails, jail in general is not good, but some jails are definitely worse than others, and I don't doubt that Rice Street is like among the worst. But I did do, let's see, I gave a talk with, I talked about the judge changes last week on Live Now. So let me play that while we wait for Meghann to get in, the other Meghann, to talk to us about Boosie. She'll refute the rumor that he was re-indicted. He has not been re-indicted, at least, unless it happened in like the last 6 hours or something. But yeah, next Tuesday should be pretty interesting to see how this new judge does. Somebody says, what about Melly? I am not completely up on the Melly case. That's why I'm having Bryson come in. Bryson follows it really closely. So he had just posted something about it the other day on Twitter. So I was thinking he could kind of keep us updated, get a virtual newsroom going on here. Put that up here for you. Here, we'll play this.
Thanks.
There's like a little bit of a delay here.
Already 3 judges assigned to this case. Let's break it down for our viewers. Why is there a 3rd judge now presiding over this?
Well, the first judge, who we'd come to know over the last 19 months, Judge Glanville, was kicked off the case after recusal motions were filed over a secret chambers meeting he'd had with a witness. The defense was upset that they weren't notified about the meeting, first of all, and then they were upset about the contents of the meeting and what happened with this witness. It didn't turn out to be the meeting that did Judge Glanville in. It was his reaction to these recusal motions. It turns out that Georgia especially has well-established case law that when a judge is hit with a recusal motion like this, they are not supposed to defend themselves on the record. There's even some case law that says no matter how defamatory they feel these statements are, they are supposed to remain neutral. And if these allegations on their face as taken as true are enough to recuse them, they need to send the recusal motion to another judge. And Judge Glanville did not do that. He initially rejected this recusal motion and defended himself on the record. And then he walked it back a few days later and ended up sending it to another judge. But by that time, it was too late. The new judge, the judge who had the recusal motions, said that he erred by defending himself and said that he needed to be removed from the case. That was the first recusal. It goes to another judge who turns out to feel that she has a conflict of interest. This is Judge Ingram in Atlanta, Georgia, Shakura Ingram. And it turns out her former courtroom deputy is the courtroom deputy who was arrested last year in the case and accused of having an inappropriate relationship with one of the defendants. This defendant actually had his case severed from trial. He is not currently on trial, but if Judge Ingram had continued on with this case, that defendant's case would be her case. So she was saying, look, my former deputy could be called as a witness here. And because of that, I could actually be called as a witness here. So she felt she needed to recuse herself. And that ends up with our third judge. That's our second recusal. And it goes to the third judge, who looks to be the new judge on the case, Judge Whitaker. She's the judge who held a status conference this morning in Fulton County Superior Court and made clear that she's going to be presiding over the trial from here on out.
See, that already was a lot to keep up with. I'm here trying to go through all of these videos, 3 different judges trying to give our viewers a picture, kind of the scene that we're getting from the courtroom. Meghann, when we first started speaking about this case several months ago by now, you had mentioned that this was going to be in it. We're going to be in it for the long haul, so to speak. I can't imagine that continuing to replace these judges is going to make this trial go by any faster, will it?
No, but I think we are done with the judge replacement wheel. And this judge appears to be much more efficient in terms of time management than we've been used to with Judge Glanville and his self-professed comfort breaks. She has made clear that she does not want any time wasted, no lapses between witnesses, and she wants to start at 8:45 every morning, which anyone who's used to watching the trial under Judge Glanville knows that would be quite a change. And just little things like that. If she does things like that and keeps them on track and no longer has these marathon comfort breaks, things could speed up a lot. We could see a much quicker trial here.
I think it's interesting that you mentioned that something about the judge, Paige Whitaker, and how she started that trial a little bit earlier. And kind of reading through reports that are online, every article mostly mentioned how she started these proceedings earlier, really trying to outline the difference between her and the previous 2 judges. I think the next question would be almost the public perception, or maybe even the jury's perception. Now that we've seen 3 judges go to preside over this case, do you think that this is going to impact the outcome of how it all plays out?
It will be interesting to see what the attorneys argue in their inevitable mistrial motions about how the jury must be perceiving this. And what's it going to be like for the jurors who got to know Judge Glanville and are right now. Just want to interrupt to say, Tasha, thank you all. Thank you for joining us. And hopefully you can, find some good information on here and find this as like a good resource for everything. And good luck in court next week. Like I said, hopefully the new changes and everything make, I don't want to say things easier, but, hopefully things will be a little less stressful for you with the trial being a little better managed. So thank you so much for joining us. I just wanted to say that. Now on a break, and presumably under order from the court, they're not supposed to be reading anything about the case. So we're supposed to give them the benefit of the doubt that they don't know anything about this right now. What are they going to think when there's a new judge on the scene? But I think the understanding is that they shouldn't read any prejudice on the defendant's half because of that. So it definitely remains to be seen, the future of the trial. I think the judge made it clear she's going to be doing everything she can to move forward with the current jury, but we still have a lot of motions to be filed, and the defense has a lot of legal arguments that they're raising, and some important ones really that need to be sorted out before we get any kind of testimony resumed here.
Let's let's outline what happened in court this morning as Judge Whitaker held a status hearing. Explain to our viewers what a status hearing is. What did we see happen?
I'd say it was a status conference, and it was more just a scheduling conference. This is when a judge isn't planning on hearing any kind of motion, and it was clear she wasn't going to make any substantive rulings because the defendants were not in court. And the defendants would need to be in court, or they would need to waive their appearances for her to be talking about substantive issues like that. This was kind of almost a meet and greet in the beginning for her and the attorneys, and then just where are we? She wanted to talk about dates, and she established some ground rules. The biggest news, first of all, being that the motions are due next Tuesday, July 23rd. Prosecutors have until Friday to respond, July 26th, and then they're back in court on July 30th, and she's looking to move fast. They're going to start at 8:45 and go all day to sort through motions, and she's trying to get the case back on track to go before a jury. But of course, there are going to be mistrial requests that she's going to be deciding. But she implemented some ground rules, like no eating in court, and that's definitely going to be a change for some of the defendants. But really, one of the biggest eaters in court that I've seen was Judge Glanville. So Judge Whitaker has said that, this isn't a movie theater. We're not going to be eating popcorn in here. She had some questions about the headphones that we often see defendants wearing. It looks like they're listening to things on laptops and things like that, and she wanted to know why. And one of the defense attorneys said that it was basically just allowed to combat boredom. And she said, well, we aren't going to be bored moving forward, and said that the listening to the headphones will stop. She also took issue with the number of outfits that the defendants have. She's regulating on the drip that the defendants are bringing into the courtroom. Young Thug has a whole rotation. I mean, we do see him repeat outfits sometimes, but not very often. But she was saying that the deputies talked to her about how they feel it's just too much. There's just too many outfits back there. So she wants them, the attorneys, to cut down on that to, about 5 a week or so. She said nobody needs to have 20 outfits back there. So that's going to be a big change, but just time management in general is going to be a big change. But so much remains to be seen about what the case is going to look like going forward, and will the jury be told that they need to somehow disregard some of the testimony that they've already heard. So yeah, I continue there, but I've got the full video if you want to watch it. But one thing I did, and I tweeted it out earlier, but the gag order request that I talked about with Doug Weinstein, the prosecutors actually cite timestamps of the certain of the interviews with certain statements that they're complaining about. So I actually put together a mashup of a video, kind of collection of the statements that they made. So I'll play that for you guys. You can see the statements that caught the prosecutor's attention here.
Shannon, I'll say it today, I'll say it tomorrow. He is innocent of the charges in this indictment.
Right, because again, I think we're winning. I don't think, as you said, I don't think any jury right now, even without us presenting any case at all, a jury could find RICO violations, or a jury could find murder. Now they're in the middle of their murder case, but I don't think it gets any better for them. I don't know. I mean, that's their call. I mean, I don't think their case is very good. Do they want to retry this? Do they want to indict it in a different way? I don't know what they're going to do. I really don't.
We don't need prosecutors doing unethical things and trying to trick the court or be dishonest to the court. We want everything to be fair, and we firmly believe that if everything is done the way it's supposed to be done, if it's a fair, unbiased part of the trial, that Jeffrey Williams is going to walk out of the courtroom and bring out. He's going to be exonerated of all of these things that he's been wrongly accused of.
I think at the present time, I think the trial's going very well for us. I think anyone that's been watching this can see that the state hasn't come close to proving any of the charges against Mr. Kendrick. He's accused of serious crimes that he did not commit. Mm-hmm. So to the extent that the public can watch what's going on and learn and see the case that the state thinks that they have against him. And of course, it's ultimately it's up to a jury to decide. And see that Mr. Kendrick is not guilty of these crimes. So we've always felt that if we get a fair trial, we're going to get a not guilty verdict.
So yeah, anyone who was watching in the very beginning saw of this interview, shout out to the replay crew, saw Doug Weinstein say hi to the prosecutors, because obviously they are watching these interviews. But he had a whole explanation about why, they will definitely be opposing any kind of gag order. And it seems like nobody's super worried. There's the Judge Whitaker is actually gonna implement this, but we will find out for sure next week. So let me see. There's a few things going on. I actually just got a notice for this case. Always gets so much attention on Twitter. Twitter is like such a limited audience these days, but it's the Kenneth Petty case, the lawsuit against Kenneth Petty, who's Nicki Minaj's husband. It's the sex assault lawsuit that was filed in Brooklyn federal court. And the plaintiff's lawyer had complained last week, filed something saying that Kenneth Petty didn't show up for his deposition. So today, Kenneth Petty's lawyers filed their response. And here it is. It is unfortunate that this discovery dispute requires the court's attention. Lawyers should be able to resolve these issues without the need of court intervention, but plaintiff counsel's unprofessional conduct and bad faith have made this impossible. Indeed, plaintiff counsel's bad faith is demonstrated by plaintiff's letter itself, in which plaintiff omits to inform the court of numerous material facts, as discussed below. And again, we're discussing another case here, not YSL, but I just got a notice on this in my inbox that this response had been filed. So it says plaintiff, that's the woman suing Kenneth Petty, who he pleaded guilty in the 90s to attempted rape involving her. And now there's this ongoing federal lawsuit. But there were limited objections by plaintiff's counsel during the deposition, although there were many improper speaking objections in an attempt to lead plaintiff's testimony. Throughout the deposition, plaintiff was questioned concerning numerous inconsistent statements and testimony she has provided concerning relevant issues, and plaintiff's responses were not credible. Clearly aware of this, plaintiff's counsel unilaterally and improperly terminated the deposition before it was concluded. So yeah, this is Kenneth Petty's lawyer giving the court the background about why he didn't show up for his deposition. And it started with the first deposition of the plaintiff that was cut off early by her lawyer, who is Tyrone Blackburn, who I think some people might recognize that name. He has a lot of different cases and has been accused of misconduct in various cases. But plaintiff alleged in the second amended complaint and testified during her deposition that an unknown third party contacted the U.S. Marshal Service concerning the alleged harassment of plaintiff in relation to her allegations against Mr. Petty, and the U.S. Marshal Service offered her, quote, witness protection. Plaintiff has made inconsistent statements concerning that allegation, e.g. texting that U.S. Marshals were at her house, but admitting that they were not. So this is Kenneth Petty's lawyer explaining what he was getting into in the deposition with the plaintiff when plaintiff's lawyer canceled it. I asked plaintiff what she had to provide in exchange for witness protection, as my understanding is that an individual must be a witness to receive witness protection. Plaintiff was obviously confused by my question, so to place the question in context, I began my next question by referring to movies without mentioning a specific movie, as I would ask something along the lines of, have you seen movies in which a person agrees to testify against criminals and receives witness protection due to testifying? Before I could complete my question, however, plaintiff's counsel began yelling, screaming, and objecting. He then abruptly terminated the deposition by signing off. again, this is Kenneth Petty's lawyer responding to the lawyer for the woman suing him, who had complained that Kenneth Petty actually skipped his deposition in a sexual assault lawsuit. Kenneth Petty is Nicki Minaj's husband, but Kenneth Petty's lawyer is explaining why he didn't show up for the deposition and saying that there's a lot of other things going on here that the judge should be aware of when he's refereeing this discovery dispute. This was just a new filing today. So yeah, so I was gonna, we're gonna move into a discussion about Boosie's case. I saw some people recklessly spreading false rumors that he'd been re-indicted. So we can squash that right now. But we've got the actual source to talk to. It's his lawyer, and she's got a great name. We'll get her on screen here. Meghann, thank you for joining us so much. Can you hear me?
Much for having me.
Yes. Do we have the volume okay? Can you confirm to the masses, is Boosie still a free man? Is he charged with any crime right now?
Earlier this week. So the government decided to move forward on 2 counts concerning the exact same conduct. Shockingly, he was. Unfortunately, as you know, I'm around the world right now visiting family in Micronesia. So I received an email morning 2 days ago indicating that the government had refiled charges, that they'd issued an arrest warrant. Wanted him to come in, or they were going to arrest him on Wednesday. So today, your time. I filed an emergency application with the court to recall the arrest warrant, and we have an appearance date next week. We're going to deal with this.
Is this the same judge in San Diego federal court? Oh, I think you cut out. I don't think we can hear you. Are you on? We heard you for a little bit, and then I think the sound cut off. Yeah, you might be muted here. Let me take you off screen and then add you back. Is your volume okay? Can you hear? I just don't. Yeah, for some reason we can't hear you. Your sound's off. Maybe if you sign off and sign back on or something, that would help. So he was charged. We did not think that they would do that unless this is Boosie's lawyer. We did not think that it would that they would recharge him until they changed the holding in Duarte. But because the Ninth Circuit is considering that ruling en banc, they all voted to hear it en banc. They actually vacated the decision that led to his dismissal. So yeah, just in the last couple of days, they recharged him. That's a bummer. But yeah, is that better? Can you hear us?
I can hear you. Can you hear me now?
Okay, great. So yeah, can you explain what happened? There were some rumors going around that he's been recharged, and it sounds like the feds did decide to recharge him because the Ninth Circuit had vacated the Duarte decision.
Right. So the Ninth Circuit, after the dismissal, vacated the Duarte decision. They're going to hear it en banc in September. So I am frankly just shocked by the fact that the government decided to move forward with charges now, just given what's been going on and developing in Second Circuit case law around the country, including in the Ninth Circuit. They recalled the Duarte decision. They depublished it so that the entire Ninth Circuit, the court as a whole, can re-review it. I am not expecting a different decision. And if you look at what decisions are coming down from other circuits around the country, other circuits are in alignment with what the Ninth Circuit found. And I believe that ultimately the Supreme Court will be in alignment when the issue comes before them, probably in the next year or so. But they refiled charges. We will again move for dismissal. There are a couple of other motions that I will be filing in addition to raising the Duarte and Second Amendment challenges. We'll be moving to dismiss on additional grounds in the coming weeks. This is, a case where Mr. Hatch was charged, as you know, initially by the state. We have one dismissal there. Charged then by the feds, second dismissal. And they're going at it again a third time. And one of the things I think that's most shocking about the newer indictments, it all involves identical conduct. So the same conduct that the state charged initially, then the federal government picked up, right? Expanding Mr. Hatch's exposure in terms of what his penalty could potentially look like. Then over a year passes, we get the second dismissal and they file a second charge. Same exact conduct, but there's questions about why, if this was a valid charge, should not have been brought initially the first time. And so we'll be raising motions concerning that charge specifically and the government's motivations for bringing the charge so late after Mr. Hatch has exercised his constitutional rights in this case.
So you said he was turning himself in today in San Diego. Is he going to have to be in custody?
He is not turning himself in today. It's next week. So I think that's where I cut out. The government wanted him to self-surrender today. That makes no sense. He was on bonds in his state case. He had no violations. He showed up to court. He showed up to court on time every time. He was on bond in his federal case. Federal case Hatch won. For over a year, no violations. He showed up to court every single time. There were no issues whatsoever. Issuance of an arrest warrant in those circumstances, something I personally have never seen. As you know, I was a federal prosecutor for a long time before I started doing defense work. That is not something that I had seen as a prosecutor. It's not something I've seen as a defense attorney. Uncalled for in this situation. We moved to recall the arrest warrant. We moved his appearance date, not a self-surrender date. An appearance date next week. So next week, August 2nd, Mr. Hatch will appear in court, not surrendering himself as the prosecution wanted him to do. Their request for an arrest warrant in this case, in my opinion, there is no justification for it. He is not a risk. He has shown that he is not a risk. Multiple courts have found that he is not a risk. On this exact same conduct, we are before the same judge as his first federal case. It is completely uncalled for. And I reached out to them before I had to move the court to recall that warrant. I reached out to the prosecutors in this case, and I asked them to do it on their own, given Mr. Hatch's history, to recall it on their own, because typically in cases like this, when a person is not a flight risk, what happens is the prosecution will just ask counsel, me, to notify their client to come into court on a certain date. They refuse to do that. So even after they sought the arrest warrant, which is something I'd never seen before in a case like this, they then refuse to recall it, refuse to set it for a hearing. And that is where we are. And that's the atmosphere that Mr. Hatch is defending himself in.
Wow, that's got to be a little concerning and such a letdown from what happened. I mean, it seemed like we had a discussion last week that there was some thought that they weren't going to refile anything until SCOTUS decided Duarte, which could be like 2 years.
Yeah, I mean, this is when the case is over, I'll go more in depth on my personal opinions about the DOJ's move in this case with Mr. Hatch and the prosecutor's specific motivations in this case with Mr. Hatch. But when you have a case like this, where there are significant questions about whether Mr. Hatch's conduct as charged is even illegal, significant questions, and you have jurisdictions across the country that have ruled that the law as applied to people like Mr. Hatch is unconstitutional, with the backdrop of the Ninth Circuit having already made that specific finding, and you decide to recharge him now, that makes no sense. The statute of limitations in the federal system is 5 years. What that means is the government has 5 years from the time that Mr. Hatch, is alleged to have engaged in criminal conduct to file criminal charges against him. We are in a state right now where best case scenario for the government, it does not look like this will be a constitutional charge for him moving forward, but there might be some ambiguity. Worst case, it's clear that they're moving forward on a charge that they know is not constitutional as applied to Mr. Hatch. Either scenario, that would be unethical conduct to move forward. They can wait until the litigation concludes in the Ninth Circuit, we're talking about a couple of months. Oral arguments in the Duarte decision, the en banc oral arguments are set for September. That means we're expecting a decision in the Ninth Circuit by the end of 2024. They refuse to wait until the end of 2024, where we're going to get clear guidance from an en banc entire Ninth Circuit panel on this specific issue as applied to Mr. Hatch. Why they decided to move forward in this manner, you can all make your own assumptions. I certainly have thoughts on that. Yeah. Why they've decided to do it so aggressively, where they've issued an arrest warrant when Mr. Hatch is not a danger, not a flight risk, has complied with every terms of supervision, both in his federal case and his state case, and why after I reached out to them, they refused to recall the arrest warrant and set it for a hearing date is ridiculous.
And it seems like the judge assigned to this case, just from being in court and seeing the way she's reacted to this, would be completely sympathetic to everything that you just said and not like what the government did. But is she going to feel like legally she can't do anything because they vacated Duarte and she just has to see what the Ninth Circuit is going to do? And she can't dismiss the case right now.
You know, I don't know what the judge is going to do, and I certainly wouldn't presume to know what's going on in her mind regarding the Second Circuit or anything else. I can tell you this, though. Cases across the Ninth Circuit right now are basically on hold where these allegations are charged. On hold. That means the government filed charges knowing that we're going to be in, there's not going to be any movement in the case until Duarte is decided. So their decision to move forward on Mr. Hatch at this time, all that means is that now he's going to have to ask for permission if the judge imposes the same conditions before he travels for work, for example. He's going to have to be subject to other pretrial conditions that everyone else who's charged with a federal case is subject to. It limits his liberties before there's any certainty on whether the charges against him are even constitutional, with the backdrop of multiple courts finding that the charges are unconstitutional. So they are intentionally limiting his liberties early, knowing that so many courts, including the Ninth Circuit previously, has found it unconstitutional as applied to him. That's just ridiculous.
Wow. Well, kind of a unexpected, unfortunate turn of events for you guys, but it sounds like you have a lot of reasons to be optimistic that this is just another temporary charge that you'll be able to ultimately get dismissed.
Right. And as I mentioned, I think the volume may have cut out. We're filing multiple motions to dismiss. I have additional motions to dismiss based on different issues that we'll raise in the coming weeks. I am extremely optimistic that this is going to be dismissed again. That said, I'm also extremely disappointed in the government's decision to move forward timing-wise now, when all it means is that Mr. Hatch's liberties are going to be curtailed. The government is going to have more control over him when they shouldn't, because they decided to charge the case, to refile charges before the Ninth Circuit has made their en banc ruling in Duarte.
Mm-hmm. Yeah, there's no way this case is going to be adjudicated before all that ends, right? So this is kind of for nothing. Well, yeah,
there are additional motions to dismiss I'll file that are not dependent on the Duarte decision. So I think there are other constitutional challenges given the government's conduct in this case that are ripe at this point. I don't know whether the judge would agree with my position and Mr. Hatch's position on those motions, but we're going to give the courts other reasons to dismiss independent of the Duarte decision, and those are going to be motions that will be filed shortly after Mr. Hatch is arraigned next week.
Yeah. And you said the charges are, it's felon in possession of a firearm. That was the previous charge, or unlawful possession of a firearm. You said there was a second charge in the new case. What are the?
There is. So they charged Mr. Hatch with possessing a firearm while being an unlawful user or addict of a controlled substance.
Oh,
I'd like to
know charge.
Right. So I just as the backdrop on this, we know that Mr. Hatch was under supervision for over a year, federal supervision. One of the conditions of Mr. Hatch's federal supervision is that he was subject to regular drug testing. There have been 0 violations. They know this. They charged an individual who, for the last year following his original arrest in this case, was regularly tested for narcotics by pretrial services and at no point during any of those tests did Mr. Hatch test dirty. So for you to be charged with this, you've got to be an addict. An addict means someone who, can't control their drug use. You've got to be a user, someone who is actively using while you're possessing the gun. Assuming that charge in itself is even constitutional, and there's significant questions about the constitutionality of that statute anyway. But even if it is constitutional, and even if it is constitutional as applied to Mr. Hatch, look at the facts of the case. And whether the motivation for charging that is legitimate with a guy who we have been monitoring, the government has been monitoring for over a year and knows has not used any narcotic during that period of time.
Yeah. Well, that's got to be, does Duarte affect that charge at all? Was there any thought that Duarte would gut that charge? Because we haven't heard that in relation to the Hunter Biden case. And is that the exact charge he was charged with and convicted of in Delaware?
It was. So Hunter Biden was charged with that same charge. It is one that is very infrequently brought. I've been practicing in federal courts for over 20 years. I've had one case prior to this where that count was alleged, and the count ultimately was dismissed. That's a tough charge to prove generally, even if the statute is constitutional, and even if the statute is constitutional as applied to the specific person. But Hunter Biden's case first was different. This is an individual who had a deep history with substance abuse. He got into treatment. He made comments to various people about his inability to kick his drug habit. He was using regularly, including afterwards. And the testimony that we saw in the Hunter Biden case showed his drug use in the days and weeks after he purchased the gun. That is very different than what we have here. What we have here is, in fact, a record that shows that Mr. Hatch was not using narcotics, that he was tested regularly by the federal government. And those tests show that he was not using narcotics. Those are the facts that we have here. But there are and have been challenges to the constitutionality of the statute on its face in other districts. And other districts have found that statute is unconstitutional both as applied and on its face for a variety of reasons. There's a district court that has found that it's unconstitutional on its face for two reasons. First, using the analysis and some of the concurring opinions in Rahimi, they found that the statute does not require some sort of judicial finding that someone is an addict, or a judicial finding that someone is a user of narcotics. And secondly, the statute doesn't have a limitation in terms of time, how long the person is not allowed to possess the gun. Other statutes have addressed it on an as-applied constitutional analysis. There are arguments that the statute is vague. What does it mean to be a user? What does it mean to be an addict? There's no clear definition of either of those. And then, of course, we've got the issues with Mr. Hatch and the fact that he's not a user or an addict. So, and we have a very clear record of that the government has and knew about before they charged the case.
Yeah. Well, what a piece of news. I saw somebody saying that in the comments earlier, that he'd been re-indicted. And like I said, I just assumed it was a rumor that wasn't true, but no, it is. You've got some more work on your hands, it sounds like. So August 2nd in arraignment then?
It will be August 2nd. I believe it's 10 or 10:30. I'll shoot over the time though.
And there's some hope moving forward that he's not going to be taken into custody. There's lots of reasons for this. It sounds like the prosecutors would prefer it, but you'll be able to make an argument that he should stay out.
Yeah, there's no reason to put him in custody right now. We've had numerous findings, and for those of you in the audience that have not followed Mr. Hatch's case from the outset, the government arrested him and put him into custody when they first charged him with his first federal case. The magistrate judge in that case then found that Mr. Hatch was suitable for bond and ordered his release. The government then moved to stay the judge's order. The judge declined to stay the order. So that meant that Mr. Hatch was still going to be released on bond. In response to that, the government then appealed the bond order. They appealed the order to the district court judge. The result of that appeal meant that Mr. Hatch statutorily had to stay in custody for 3 days. And it was over a weekend, so that 3 days actually turned into 5 days. He should not have been in custody those 5 days. In front of the district court also found that Mr. Hatch was not a flight risk, that he was not a danger, and that he was suitable for bond. She thereafter released him on bond. He's been on bond the entire time. There have been 0 violations. He's been performing beautifully, as anyone would expect of him. And he's been doing fine. So there's been no change of circumstance to justify putting him in custody. I don't expect that the judge would. Of course, I am not the judge. I don't have a crystal ball. I don't know what she is thinking, but there's no part of me that would expect a court to find that Mr. Hatch now is a flight risk given his history of compliance with court orders.
Yeah. Well, okay. What else should we know? Is there anything else you wanted to say before we?
I think that's it. No, if you've got any questions, let me know. I'd be happy to answer them to the extent I can. I'm, again, just very, very disappointed in the government's decision to move forward right now.
Yeah, that's disappointing for everybody involved in that on that side of the case. I can tell. Well, it sounds like we'll have to look forward to next week and see what happens on August 2nd, and I'll check back with you then.
Sounds good. Thanks again. Have a great day, everyone.
Yeah, thank you so much for joining us.
Thank you again. Bye.
Gosh, that's some breaking news on here. I did not know that was going on. Gosh. So yeah. I mean, somebody was saying I thought this was about YSL, and we talked YSL for the first hour. So I can don't blame me if you want to go back and rewatch that, but wanted to get some more news in and wanted to do some recordings. So here I'll be able to, once this gets saved, I'll be able to splice that out and make it its own video explaining Boosie's case. And then just as me, I'm trying to think, I'm like August 2nd. I'm like, I don't think I can go down to San Diego that day, especially being in LA. It's kind of a haul, but it was worth going down the last time when his case was dismissed. But I'd like to go down there again next week, but that's actually the dismissal hearing in ASAP Rocky's first-degree assault with a firearm case too. I don't know if you guys know about that case, but he's scheduled to go to trial in October 21st. But there is a dismissal motion filed by Joe Tacopina, so gotta catch up on that one. We'll wait a few minutes here. Bryson Paul was gonna tap in and join us on update us on the Melly case, because we got to get some kind of virtual newsroom going on here, because there's just too many cases going on. It's not possible to expect me to be able to keep track of all this stuff, but I know Bryson keeps up on the Melly case pretty well, so I was thinking he could come in and help. But somebody says they're in West LA. No, I'm not in San Diego. I'm actually up in LA now. Boosie's case next week is in San Diego, and I was just kind of thinking I can't really make it down there. There's too much other stuff going on around here, and that's like such a long drive. But I went down there for the dismissal hearing the other week, but I'll just have to see what's going on. But there's no way he's not going to plead guilty, and they're not going to be able to get a conviction on that case until after the Duarte decision, that Ninth Circuit decision, is decided, and that's going to go all the way to the Supreme Court. So somebody asked about ASAP Rocky going to trial. It's a state case, a state criminal case in LA Superior Court. He's charged with 2 counts of first-degree assault with a firearm. For the alleged victim is his friend from high school, ASAP Terrell Efron. But I went to the preliminary hearing last year, and they've got surveillance video of it's a confrontation on Hollywood Boulevard, and they were having, there was a text message chain that Relly was part of with Rocky, and they were arguing about different things, and Rocky set up to meet him at the street corner, and Relly went thinking that they were just going to talk about things. And he claims that Rocky accosted him with a gun and then later fired shots, and the bullets grazed his knuckles, he says. So there's 2 counts of first-degree assault, but there's a dismissal motion filed over what happened in the preliminary hearing, because his lawyer, Joe Tacopina, who's known nationally for a lot of stuff, actually represented President Trump and some stuff, was cut off on asking certain questions of Relly during the preliminary hearing. So he filed a dismissal motion over it. I think it's a stretch, but there's going to be a hearing on August 2nd on that. So I think I need to go to that. It's going to be here in LA, but that's apparently the same day that Boosie's going to be in court in San Diego. Gosh, what a bummer. Here, this is the Relly thing. This is ASAP Rocky. From his preliminary. That's Relly. Or that's Rocky. And this is the shooting that's like much farther away. They're like back there. It's harder to see. But yeah, all this is supposed to go to trial soon. October. Pretty much it. It's kind of hard to see. It's a little grainy, but that was the evidence that was played at a preliminary hearing. But that's for ASAP Rocky on October 21st in LA trial, unless he gets it dismissed, which I think is unlikely. One thing over in the chat, I did see, I did ban somebody. I saw some comments, and I do need to get a moderator in there, but apologies if there's been, some shitty stuff shared in there and stuff. I did ban that one guy. So hopefully I don't want people in there trolling everybody. And I mean, for the most part, I don't want to restrict anyone on there. Like, people can kind of say whatever they want, but if people are just trolling and saying racist things or just harassing people and stuff, we don't want that. So we want to be able to keep the chat going. Jason Hodges asked if I have a Rule 22. I'm not sure. What is that Rule 22? Rule 22 what? Oh. I'm messaging Bryson here. I think I had a little bit of a time change dealing with West Coast, East Coast stuff in the time stuff. It's always off on there, but yeah, I got to get my friend Shadra. I know my friend from college in Portland would be happy to do the moderating for me. It's just kind of a matter of getting a set time. But yeah, I'll see if Bryson can drop in now. I think I told him 3:30 and it's 2:30. Whoops. Probably can't hang out here for another hour, but we'll see if he can drop in. Sending love from Chevenport, Louisiana. Don't let anyone silence you. That's a good motto. But yeah, let's bring up the again the motions that are filed in the YSL trial. We've got the bail motion and the mistrial motions, but then one that caught some headlines is their prosecutors basically asking for a gag order in the over statements the defense attorneys have made. But here's the, let me pull it up here for you. Here it is. State's motion to restrict extrajudicial statements. I mean, that's a gag order, right? Georgia Rules of Professional Conduct 3.6 prohibits lawyers participating in litigation from making extrajudicial statements a reasonable person would, quote, believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. And again, the essential defense to this is the jurors aren't supposed to be watching anything extra about the trial. So if they are and they're seeing this stuff, the problem is much bigger than just the defense attorneys need to stop talking. But says with criminal jury trials being, quote, the most sensitive to extrajudicial speech, the character, credibility, reputation of a party, and any opinion as to the guilt or innocence of a defendant are subjects deemed to be more likely to have a material prejudicial effect on a criminal proceedings. Defense counsel have made numerous extrajudicial statements explicitly about this case while a jury is sworn and seated during the state's case in chief. Defendant Williams' counsel, attorney Brian Steele and Keith Adams, defendant Kendrick's counsel, attorney Doug Weinstein, and defendant Stillwell's counsel, attorney Max Shard, have all made extrajudicial statements to the media explicitly discussing this case in violation of Rule 3.6. I think whether they violate 3.6 is definitely up for interpretation. The extrajudicial statements have included many other things, interviews and statements to the Associated Press. Have included, among other things, interviews and statements to the Associated Press. 4 of those interviews have been 25, 33, 43, and 107 minutes in length. The statements include, among other things, the attorney's views and opinions about the case itself, opposing counsel, the now former judge, the jury, the outcome, and the guilt or innocence of specific defendants. Pursuant to OCGA 15-1-3-4, courts have the power to control, in the furtherance of justice, the conduct of its officers and all other persons connected with the judicial proceeding before it in every matter appertaining thereto. The state thus moves this honorable court to instruct the defense to refrain from making extrajudicial statements about this case moving forward, which I think that's a gag order. Sounds like a gag order, right? So again, I put together, the motion goes through and cites interviews, and you see this down here, it says excerpts, and it gives timestamps. I went through and recorded at those timestamps and put it all together in a little video mashup for you guys. Oh, excuse me. See these timestamps right here? This is what I put together. They kind of highlight some comments that they feel are not good. This 5-second comment from Max Shard in his hour and 40-minute interview. But let me pull this up for you. I played this earlier, but we'll keep it going.
And the reality is, Shannon, I'll say it today, I'll say it tomorrow. He is innocent of the charges in this indictment.
Right, because again, I think we're winning. I don't think, as you said, I don't think any jury right now, even without us presenting any case at all, a jury could find RICO violations, or a jury could find murder. Now they're in the middle of their murder case, but I don't think it gets any better for them. I don't know. I mean, that's their call. I mean, I don't think their case is very good. Do they want to retry this? Do they want to indict it in a different way? I don't know what they're going to do. I really don't.
We don't need prosecutors doing unethical things and trying to trick the court or be dishonest to the court. We want everything to be fair, and we firmly believe that if everything is done the way it's supposed to be done, if it's a fair part of the trial, Jeffrey Williams is going to walk out of the courtroom and he's going to be exonerated of all of these things that he's been wrongly accused of.
I think at the present time, I think the trial's going very well for us. I think anyone that's been watching this can see that the state hasn't come close to proving any of the charges against Mr. Kendrick. He's accused of serious crimes that he did not commit.
Mhm.
So to the extent that the public can watch what's going on and learn and see the case that the state thinks that they have against him. And of course, it's ultimately it's up to a jury to decide and see that Mr. Kendrick is not guilty of these crimes. So we've always felt that if we get a fair trial, we're going to get a not guilty verdict.
So yeah, there you have it. Those are the statements in question that the prosecutors cited. Lee, I see your comment. You say you missed the whole live, but you're here now, so you'll be able to see the end, and you can catch the replay. And I'll try to splice some things out into different videos for you guys, especially the stuff about Boosie's case being back, being refiled. That was some news to me. Let's see here. And yeah, I mean, somebody says they said nothing that would hurt the state's case. Love is really reaching. Thanks for that, Meghann. You're welcome. You're welcome. And the problem would have to be if, I mean, are jurors going to see that? They're not supposed to. They're not supposed to be watching that stuff. So, I'll see. Let me see here. Yeah, kind of just go over some random news here. I mean, obviously this was YSL focused, but there's kind of some other stuff going on that I'm kind of bouncing around on here. So, again, the Kenneth Petty's lawyer responding to the lawyer who's suing him for sexual assault and complained last week that Kenneth Petty didn't show up for a deposition. They filed their response to that. The Kenneth Petty's lawyers did. So I went over that. And then, Toria Williams comes in. She said, Boosie's case has been refiled by the state, not the state, the feds. But yeah, the feds in San Diego have charged him again. And they've charged him not just with felon in possession of a firearm, but the Hunter Biden charge, the purchasing a firearm or like possessing a firearm when you're a drug addict, which Hunter Biden, I think anyone who paid attention to that case, and if you go rewind into the video, I have Boosie's lawyer talk about this. I mean, Hunter Biden's drug addiction was pretty well documented, whereas in Boosie's case, all the federal government has against him is a bunch of negative drug tests that he's taken over the last year. While he had his other case pending, he was out on supervision and needed to take drug tests, and he passed every single one of them. So I'm not sure. It seems like a pretty petty move from San Diego, but guys, like, I've always heard that about. I mean, maybe they would have recharged him in Los Angeles federal court too, but San Diego federal court is conservative. Like I mean, when I first saw that he was charged with that, I'm like, oh, that's not good. And the prosecutor on the case, like the main prosecutor on the case, is not like a nice prosecutor. He's like an older guy who I'm sure would just enjoys putting people in prison. So yeah, they did recharge him. Meghann, his lawyer, talked about that pretty extensively and explained what's going on. He's going to be in court next week in San Diego. The thinking is that he's not going to be taken into custody, but yeah, he was free for like a week or two. And because the Ninth Circuit agreed to review the decision that led to his dismissal, the Ninth Circuit is now reviewing that on a larger scale. So they vacated the earlier decision. So under that, prosecutors feel they can recharge him, which is true. I mean, obviously they can, but his lawyer got into all the reasons that's like problematic, that they're now implementing. They're now putting more restrictions on his freedom when they know that case isn't going to be adjudicated until all the Ninth Circuit stuff gets worked out. So that was interesting. Kind of some big news there. I'm not sure. See how long we can keep going here. Bryson is scheduled to drop in. It's not for like 45 minutes. I'm going to see if he can get in a little bit earlier, but I don't want to just end the live and start over. But I'll replay this this discussion I did from last week, where I kind of break down what's going on with the YSL case with the judges and everything. They've already heard. That's one big legal issue. That
Meghann Cuniff. Here's their conversation with these updates.
43 judges assigned to this case. Let's break it down for our viewers. Why is there a third judge now presiding over this?
Well, the first judge who we'd come to know over the last 19 months, Judge Glanville, was kicked off the case after recusal motions were filed over a secret chambers meeting he'd had with a witness. The defense was upset that they weren't notified about the meeting, first of all, and then they were upset about the contents of the meeting and what happened with this witness. It didn't turn out to be the meeting that did Judge Glanville in. It was his reaction to these recusal motions. It turns out that Georgia especially has well-established case law that when a judge is hit with a recusal motion like this, they are not supposed to defend themselves on the record. There's even some case law that says no matter how defamatory they feel these statements are, they are supposed to remain neutral. And if these allegations on their face could, as taken as true, are enough to recuse them, they need to send the recusal motion to another judge. And Judge Glanville did not do that. He initially rejected this recusal motion and defended himself on the record. And then he walked it back a few days later and ended up sending it to another judge. But by that time, it was too late. The new judge, the judge who had the recusal motions, said that he erred by defending himself and said that he needed to be removed from the case. That was the first recusal. It goes to another judge who turns out to feel that she has a conflict of interest. This is Judge Ingram in Atlanta, Georgia, Shakura Ingram. And it turns out her former courtroom deputy is the courtroom deputy who was arrested last year in the case and accused of having an inappropriate relationship with one of the defendants. This defendant actually had his case severed from trial. He is not currently on trial, but if Judge Ingram had continued on with this case, that defendant's case would be her case. So she was saying, look, my former deputy could be called as a witness here. And because of that, I could actually be called as a witness here. So she felt she needed to recuse herself. And that ends up with our third judge. That's our second recusal. And it goes to the third judge, who looks to be the new judge on the case, Judge Whitaker. She's the judge who held a status conference this morning in Fulton County Superior Court and made clear that she's going to be presiding over the trial from here on out.
See, that already was a lot to keep up with. I'm here trying to go through all of these videos, 3 different judges trying to give our viewers a picture, kind of the scene that we're getting from the courtroom. Meghann, when we first started speaking about this case several months ago by now, you had mentioned that this was going to be in it. We're going to be in it for the long haul, so to speak. I can't imagine that continuing to replace these judges is going to make this trial go by any faster, will it?
No, but I think we are done with the judge replacement wheel. And this judge appears to be much more efficient in terms of time management than we've been used to with Judge Glanville and his self-professed comfort breaks. She has made clear that she does not want any time wasted, no lapses between witnesses, and she wants to start at 8:45 every morning, which anyone who's used to watching the trial under Judge Glanville knows that would be quite a change. And just little things like that. If she does things like that and keeps them on track and no longer has these marathon comfort breaks, things could speed up a lot. We could see a much quicker trial here.
I think it's interesting that you mentioned that something about the judge, Paige Whitaker, and how she started that trial a little bit earlier. And kind of reading through reports that are online, every article mostly mentioned how she started these proceedings earlier, really trying to outline the difference between her and the previous 2 judges. I think the next question would be almost the public perception, or maybe even the jury's perception. Now that we've seen 3 judges go to preside over this case, Do you think that this is going to impact the outcome of how it all plays out?
It will be interesting to see what the attorneys argue in their inevitable mistrial motions about how the jury must be perceiving this. And what's it going to be like for the jurors who got to know Judge Glanville and are right now on a break and presumably under order from the court? They're not supposed to be reading anything about the case. So we're supposed to give them the benefit of the doubt that they don't know anything about this right now. What are they going to think when there's a new a judge on the scene? But I think the understanding is that they shouldn't read any prejudice on the defendant's half because of that. So it definitely remains to be seen the future of the trial. I think the judge made it clear she's going to be doing everything she can to move forward with the current jury, but we still have a lot of motions to be filed, and the defense has a lot of legal arguments that they're raising, and some important ones really that need to be sorted out before we get any kind of testimony resumed here.
Let's outline what happened in court this morning as Judge Whitaker held a status hearing. Explain to our viewers what a status hearing is. What did we see happen?
I'd say it was a status conference, and it was more just a scheduling conference. This is when a judge isn't planning on hearing any kind of motion, and it was clear she wasn't going to make any substantive rulings because the defendants were not in court. And the defendants would need to be in court, or they would need to waive their appearances for her to be talking about substantive issues like that. This was kind of almost a meet and greet in the beginning for her and the attorneys, and then just where are we? She wanted to talk about dates, and she established some ground rules. The biggest news, first of all, being that the motions are due next Tuesday, July 23rd. Prosecutors have until Friday to respond, July 26th, and then they're back in court on July 30th, and she's looking to move fast. They're going to start at 8:45 and go all day to sort through motions, and she's trying to get the case back on track to go before a jury. But of course, there are going to be mistrial requests that she's going to be deciding. But she implemented some ground rules, like no eating in court, and that's definitely going to be a change for some of the defendants. But really, one of the biggest eaters in court that I've seen was Judge Glanville. So Judge Whitaker has said that this isn't a movie theater. We're not going to be eating popcorn in here. She had some questions about the headphones that we often see defendants wearing. It looks like they're listening to things on laptops and things like that, and she wanted to know why. And one of the defense attorneys said that it was basically just allowed to combat boredom. And she said, well, we aren't going to be bored moving forward, and said that the listening to the headphones will stop. She also took issue with the number of outfits that the defendants have. She's regulating on the drip that the defendants are bringing into the courtroom. Young Thug has a whole rotation. I mean, we do see him repeat outfits sometimes, but not very often. But she was saying that the deputies talk to her about how they feel it's just too much. There's just too many outfits back there. So she wants them, the attorneys, to cut down on that to, about 5 a week or so. She said nobody needs to have 20 outfits back there. So that's going to be a big change, but just time management in general is going to be a big change. But so much remains to be seen about what the case is going to look like going forward, and will the jury be told that they need to somehow disregard some of the testimony that they've already heard? That's one big legal issue that's coming up, is everything that Judge Glanville did after the recusal motions were filed against him. What's going to happen to that? Because the jury heard a lot of testimony from the key witness at the heart of the secret chambers meeting after that. And Georgia law states that when a judge is recused, everything the judge did after the recusal motion, or there's some precedent that it's invalid for the trial. So that would be much of Kenneth Copeland's testimony. So right now it's a question of what is that going to look like, and what's the Judge Whitaker gonna say going forward on that. And then, of course, the big question is if we're going to see the jury again, and then when are we going to see the jury again?
Meghann, I just have to point out a couple of things that you did mention that I found really interesting, kind of these new rules that the judge has imposed, regulating on the drip. It is something that we have seen Young Thug kind of in different outfits every day, kind of flashy, this eating in the courtroom. It almost seems like, when you get a new teacher in a classroom and they start kind of cracking down on what's going on within those walls. What does this say about maybe what this judge even thought at how this was kind of all going up until now before she took over this case? And how do those little changes even affect trial proceedings?
I think a lot of this was her probably knowing that she was taking over such a high profile case. I think it would be standard for judges to want to meet with the sheriff's department about such a high profile, high security trial and just say, hey, how are things going? What are some things that I should know? And pretty clearly, the sheriff's office had a wish list about things going on in the trial that they have some concern with. So I'm sure that's how that came about.
Let's talk about these motion hearings that we're going to have next week. So today, this status conference, as you mentioned, with the attorneys there meeting with the judge, this sort of meet and greet. So next week, we're going to get down to more official business, would you say? And how is that going to look? What are we going to hear from the defense and from prosecutors?
I think the two big issues right now are mistrial motions. Some attorneys do feel it's in their client's best interest that they start over. That there's been too many errors baked into this case, and that just the issue with Kenneth Copeland's testimony and the invalidation of it that might happen warrants a mistrial. There's also the issue of, did the prosecutors, by being involved in this ex parte meeting with the judge and the witness, did they make themselves witnesses themselves? And Young Thug's lawyer is arguing yes, and he's actually filed a motion asking for them to be recused. So it's things like that if theoretically the prosecutors were recused from the case, obviously that would be a big setback, and the idea that this would just continue as is doubtful. But those are the kind of issues we're going to see the judge deal with on the 30th. The big ones are, should there be a mistrial? Should the defendants get bail? It's unclear when exactly she's going to consider bail requests, but we've already gotten one bail request in. And because the 6 defendants actually work together in that it's assumed that when one of them files a motion, they all join in on it unless they vocally say, no, I don't want to be involved in this motion. So they've technically all requested bail under this one bail motion, but I do think we're going to be seeing separate filings on that from their own attorneys, just because that's such a crucial issue. But the big issues are mistrial, bail, and then what do we do about Kenneth Copeland's testimony and what portions of it are supposed to be invalidated?
You know, Meghann, this is one of those trials that I think it would be impossible if in one conversation we were able to kind of detail everything that is important that viewers need to watch out for, given all the changes that have happened within the courtroom and all of the witnesses that we've already heard from. So I guess really the final point that I would like you to make is, what do we need to be out on the lookout for going forward? Anything that we really should focus and hone in on? What should the viewers' takeaway be from this trial thus far?
I would definitely encourage anyone who's interested in the trial, especially if testimony does resume, is to really look at what the evidence is about this supposed organized crime conspiracy that has 6 men, really more than that, because there are co-defendants who aren't on trial right now, who are actually awaiting trial in jail. Look at the evidence that they have that's keeping these men behind bars without bail, and ask yourself if it's enough, and if they've shown enough to really justify what a big case this is, when the prosecution seems to be lacking in a lot of areas. And hopefully this renewed focus on the case will kind of bring some new attention to the evidence and the testimony if it gets going again.
Meghann Cuniff, legal affairs journalist, always a pleasure to have you with us here on Live Now from Fox. You help us really understand and examine, dissect all of these trials, these cases that we monitor very closely. We look forward to checking in with you, Sue, and kind of can't wait to see how this time plays out. Again, a 3rd judge, the newest one appointed to
This is Democracy Now!, democracynow.org.
Yeah, there we go. Like my friends at Fox Live Now, I have a few of those that I go on regularly, but they're the ones who give me the most airtime. They'll just freaking let me talk and put it on the air. So it's pretty great. But that was from last week, just going over the trial. We haven't had any any big changes since then, except the gag order request is probably the big one. And there's been some other filings from Brian Steele. Brian Steele's filed the request for mistrial and for bail for Young Thug. And then he's also filed something asking the judge to reconsider the ruling from the other judge that the ex parte was proper. So that's pretty substantial. And but for the replay crew, or for anybody who's kind of just joining, if you go back, like the first hour or first 45 minutes of the discussion of this is all about that. It's with Doug Weinstein, and we're going over the motions and talking about the gag order and his response to that and everything. So simple Todd, good interviews, Meghann. Thank you. I like doing the interviews. And as a print reporter forever, I have done so many interviews. I mean, especially for the Daily Journal, when I had to profile judges, I've done big 2-hour interviews, sit down and talk for 2 hours, never in front of a live audience though. I mean, that interview I did with Max Shard, that was like an hour and 40 minutes. I'd never, when you're a print reporter, you'll record the interview and you'll get the quotes and you'll write a big story like later on, but to have somebody like watching you do the interview, you just don't really see that very often. And I mean, we see that on the network news, like 60-minute interviews. But I mean, even from the time I was a little kid, it always seemed like those interviews were, there's just little splices. You don't get to see like the full interaction. And I think it's because, part of news packaging is packaging it together efficiently. So somebody doesn't have to spend an hour and 40 minutes, like just to get some information about a case. But I think there's something to be said for both areas. I like SR Rena. Good. I see. I like this. No new subscriber. I like your breakdowns. No fluff and to the point. Try to be. Yeah. I mean, I know I probably, my thumbnails are a little lacking. I don't have all like the good graphics that people have. And I just cannot bring myself to like sensationalize the headlines. I just can't do it. I mean, maybe a little like, you're trying to emphasize the words that are going to get people's attention, but all those headlines that are like, judge roasted, you won't believe what happens next. I can't, so maybe I'm losing some immediate subscribers or immediate views, but I hope in the long run, I'll be able to get, more of a loyal audience about that. So, breaking it down with B. Yeah. So we'll see here. We've got half an hour before I told Bryson to drop in. I checked to see if he could maybe check in early, but it's kind of my fault that's one thing that covering the Young Thug trial has made me think in terms of national times. I mean, I lived on the West Coast my entire life, and I've always been aware that the East Coast is 3 hours ahead. But just when you're dealing with national stories and talking to people who live on the East Coast, you just start to get that more programmed in your brain, that the time differences and everything. So, but the big news is everything starts up next Tuesday the 30th at 5:45 a.m. California time. That's 8:45 a.m. in Atlanta. Judge Whitaker is supposed to be convening everybody, and she's going to start going through all these motions. So like I was talking about with Doug Weinstein, it's going to be interesting just to see what is the first thing that she wants to deal with. And we're just going to find out so much about her approach and how things are going to go forward on Tuesday. So I mean, like he was saying, it seems like Doug Weinstein was saying, it seems like the mistrial or the recusal motion against the DAs that Brian Steele has filed would be the one, maybe that one's most pressing to deal with, because if she grants that, if she recuses the prosecutors, then it's, what happens to the case after that. But I'm not sure. It's just anyone who watched that hearing, just her tone, she was so just like, we're moving forward. I mean, she just sounded, that she was in here to get the case back on track and move it forward, not to end it. So, but I think there's going to be some arguments that will be pretty hard for her to ignore here. So let me see. I wanted to bring up highlight from Max Shard's interview. Oh, where are the reports? Oh, the Brady violations too. I was gonna post this. I haven't posted yet. I just caption, but here, let me pull this up for you. Because this is when I asked Max, what are the Brady violations, or what Brady violations do you see? And Brady, I was actually just going to be typing this into the caption on the video, but when they say Brady, they're referring to a 1963 U.S. Supreme Court case, Brady versus Maryland, that says prosecutors have to disclose any evidence that could be considered exculpatory to the defense. So it's so commonplace, and we hear about it so much in criminal law in the United States that people just say Brady. Oh, it's Brady evidence, and everybody just knows that they're talking about Brady versus Maryland. But it's one of the more commonly cited one. That and Jenks and Gigolo is another one. But the Brady material and of course, that's what led to the dismissal in the Alec Baldwin case. And we talk about that a little bit here. But the fact that the prosecutor didn't disclose some rounds that had been submitted in the middle of Hannah Gutierrez Reed's trial, the judge found that to be a Brady violation that warranted the dismissal of the case with prejudice. So Max is talking here about some of the Brady violations that he perceives have happened in the YSL trial. Our channel by Angle, new subscriber, loved and agree with your breakdown. Thank you so much. I really I love the for the people format of YouTube. Like I said, I like that live now from Fox that always has me on, because they just let me talk. I mean, they have let me talk for like 30 minutes before, and they just put it all on air. I mean, usually it's live, but sometimes they'll do some pre-recorded stuff where they just put it on air. Whereas, I mean, some other podcasts that I've done, it's like you'll talk to them for 30 minutes and they'll use like 3 minutes of your talk. And when you listen to what they actually put together, it's so superficial, because they put it together for people who don't know anything about the case at all, which, okay, there are a lot of people in America, but obviously my coverage is a little more geared toward people who are covering it. I'm not going to spend the first 30 minutes or the first 30 seconds of my video explaining who Young Thug is and that he lives in Atlanta and is charged with a crime. I mean, there's just all this like stuff that they need to get into that just feels like a waste. And it just leads to like really superficial coverage where it's like, okay, that was a really big podcast and it got a lot of views, but I mean, they didn't say, they offered really nothing like new in the case. But here, I'll play my interview with Max Shard while we wait for Bryson to give us a Melly update.
Win this case. We're trying to be as prepared as we can to address the witness on the stand. We're not strategizing for appellate issues or to create appellate issues. And quite frankly, in my estimation, there has been Brady violations. So where have Brady violations gotten us? Not too far. And so, I just wanted to know what was going on, so I could best deal with what was right in front of me. And I think the rest of the attorneys did as well.
And before that, can we, what are the biggest Brady violations that have occurred, just in terms of like, I mean, we talked about some discovery violations, but just in terms of like pointing to what do you think stands out the most? Well,
there's reports, there's all sorts of, and this is the problem when you have, I think it's fair to say that in some ways law enforcement went about things in a more informal manner than we would expect. And I'm not saying that's a bad thing, but there's been many conversations that did not take place in an interrogation room that were videotapes. We hear about one witness, the gentleman involved in the Adrian Bean situation. We hear about a recording being erased. We hear about Mr. Copeland meeting with people at Turner Field. We hear about all these different meetings where there's no documentation of. And Brady, most people think, oh, Brady means you have the DNA of someone else, on the crime scene, they need to hand that over, or the DNA doesn't match the accused, they need to hand it over. But it also deals with impeachment. So every time a witness says something that's contradictory to what they've said previously, that's
Yes.
impeachment. That's Brady. So we have all these informal statements where we don't have reports, and all these meetings that there's not even documentation of, that we hear about through Kenneth Copeland just kind of talking, sometimes talking on, I was watching YouTube, sometimes talking about, oh, I met with so-and-so here. We had, he was on YouTube talking about his time in the federal system and all these bizarre meetings. And we just don't have any documentation of any of that. So I don't have a lot of faith that we've received everything that we're supposed to have. Where we go from there, I'm not sure. But, it's troubling because the law says we're supposed to have.
Yeah. And I think the Alec Baldwin case, at least I think the criminal defense bar is hoping that's kind of a wake-up call, or at least the judge's endorsement of Brady evidence there was pretty strong, but it's just a matter of how does that translate to other courts.
Right. Because in that case, essentially, as I understand it, the prosecutor was essentially saying, well, I didn't hand it over because I didn't deem it important. And it's like, well, it's not only you that gets to decide what's important. We get to decide. We get to choose our defense. We get to decide what's important too. And if you never even give it to us to make that determination, then that's fundamentally unfair.
Well, and it seemed like Glanville, I mean, I can remember some quotes from him where it's like he talks a good talk, but he doesn't really follow up the walk because he would never really do anything about it when you guys would complain. But I remember his speech where he was obviously talking about Fonnie Willis, where he said your DA used to be, he used to do cases with her all the time, and that she would tell him, you can have my whole file because if you can beat me with it, then you deserve to win. And it was like, okay, that sounds great, but where is the enforcement of that in this case? And it was the same with him talking about how, oh, why can't you be more like federal practitioners? It's like, well, probably because the judge doesn't have any kind of standards close to what federal practitioners are forced with. I mean, were you guys kind of working within the constraints of the system? Like you could have done differently elsewhere?
There's the system as in the way what the law says, and there's the system as the way people are used to doing it. And I think in this case, again, I don't mean to be a kiss up, but again, this case has a certain following and it's been televised live on the internet for thousands of people to see, maybe hundreds of thousands. And so a lot of the stuff that's normalized doesn't necessarily fall through the cracks here. And I think that maybe just everyone in general, and defense attorneys, prosecutors, judges, and I'm not singling anyone out, need to really evaluate kind of if we've gotten used to doing things a certain way and, oh, that's okay because no one's ever complained about it before. So why wouldn't that be okay? With the ex parte meeting, I mean, I don't believe that was okay. Okay. But am I going to sit here and say, well, in Fulton County Courthouse, that's the only time something like that's ever happened?
Yeah.
I can't say that. I don't know, but I think things like that happen when we allow it to be normalized. And hopefully this is just a reset. And hopefully Alec Baldwin's case is just a reset for, maybe we're cutting corners. And I'm not blaming, again, I'm not putting on anyone. It's just as a system. And defense attorneys have a role in that too. If we allow things to happen, they're going to happen. And so that's why, when Brian stood up, it was brave. Because there's not a huge history of people just standing up and calling things out. But that's what needs to happen to kind of reset sometimes, I believe.
Well, and one thing I've noticed from from covering courts over the years, you learn that there really is no centralized database of how to track all this stuff. I mean, you can look up case law, but there's no way to find out. It's like, okay, how many judges in the last week dismissed this charge? I mean, I'm sure are you on email listservs with like the other defense attorneys in the Fulton County area where you kind of share cases and things like that? But that's basically it for a centralized database.
Right. And you know, as a member of the press, I mean, you would even the local press, you know, I don't even know how they would, if they wanted to find other cases, that you would have to almost figure out who the attorney was and figure out how to get that information. There's nothing centralized. And of course, you know, there's privacy concerns and everything else with it just being all public. You know, if I went to trial for accused of something very bad and I was acquitted, I don't know if I'd want the public just to be able to look me up and my case up at any time, because, you know, even when you're acquitted, people think a certain thing. So I don't know what the answer is, but yeah, there's no centralized information to kind of get at some of these things. And then, you know, once in a while you say, oh yeah, I've dealt with that officer, but you run into another attorney. I've dealt with that officer before, you know, this is what happened. And you kind of get information that way, but it's really, you got to do your digging and your due diligence. And even then you need some luck and you need someone else that's willing to cooperate to give you information.
Yeah.
So,
well, yeah, great. Well, I'm trying to see if we have some questions in the chat here. That's from last week here, just giving you guys a clip. I just published that to YouTube. That's kind of one thing I'm learning is it helps the readers when you do or the viewers, when you do a big hour and 40-minute interview like that. It was great. I mean, we have 1,500, maybe 2,000 people watching us throughout. And then the video is up to 20,000 views. But so many people, when they just want to catch up on something, would see an hour and 40-minute thing. And it's too long. So it's important to cut it all out into other videos for people to watch. It'll kind of spread it around. So yes, as Toria says, hit that like button. Hit that like button. Let the algorithm know that I am here. I want to take over YouTube and make this the channel. But we got about 10 minutes until Bryson was going to come in. But, I was just thinking about that. I was like, there's so much going on. And if I can develop a platform where people Bryson can drop in when he's covering a case and, just kind of get some field reporters to cover other cases for us and share. I mean, the YSL trial is going to be going on forever. I've talked to that Thugger Daily guy just on DM about could there be some way to collaborate on stuff? I mean, he's got the dominance on Twitter, but he's so on all the court documents and everything. And I mean, he was open to whatever, but it's just kind of if I was making a news team, assembling a news crew, I would hire him for that. Because I mean, clearly he's slanted, but you can have a columnist cover a trial. I mean, an opinion columnist or something. You'll see that in traditional coverage and everything, but it just seems like we've got a lot of potential here to get a team together to cover everything. Because you just kind of have to remember that there's so much going on, and you're gonna stretch yourself too thin if you just try to cover everything. So thank you guys. Yeah, the defense has great attorneys. The state is the problem. They do. That was in the very beginning of the trial. Because like I said earlier, if you guys have been watching, I was telling Doug Weinstein that legally this trial was not very interesting in the beginning, because it's not a real RICO case. The prosecutors don't know what they're doing in terms of a conspiracy case. The judge was in way over his head, and all the testimony was about some drug bust or something from 10 years ago. But the defense attorneys were good, and the defense attorneys have always kind of helped make it a little more watchable just through their lawyering and then everything that's happening. But then I feel like the trial has gotten a lot more intriguing legally in the last few weeks with the recusal of Glanville, and now the big question of how does this trial proceed under another judge. And I think that's what we're going to be really getting a close-up view starting next week, starting next Tuesday at 8:45 a.m. in Atlanta, when Judge Whitaker starts her motion hearing. I think we're going to be really seeing some interesting legal issues dealt with. Of just, I mean, how does a trial even move on like this? I saw a question earlier. Somebody asked what I think of Bruce Harvey's motion, and yeah, I read that aloud yesterday on the live and was like, okay, I'm persuaded. I mean, of all the mistrial motions, I feel like his was just the, how can you argue with this? And his isn't even based on anything regarding Woody, things like that. It's all just about how can a new judge take over a case this complex 19 months in and be expected to make informed, intelligent decisions about, such as at the end of the trial, and this is pretty standard in any trial, you'll see the defense move for a judgment of acquittal, saying that just based on everything presented, the judge should be able to make a decision that there isn't even enough evidence to send this to the jury. And how can a judge who just came into the trial like 18 months in, how can they do that when, I mean, it'd be one thing if it was a really simple trial that had only been going on for a week and it was just a couple days of testimony that they missed about, a single assault case or something. But this is pretty complex. And Judge Whitaker was like, oh, I'm not going to revisit all that stuff. And it's like, really? Like legally, is that can? I mean, Bruce Harvey makes the point in his motion that it's completely understandable. It would be like, it's not feasible that a judge could catch up with all this stuff. But here's the motion right here. But that's one of the mistrial motions that will be dealt with starting Tuesday at 8:45 a.m. So, and then also the reply to this. It's going to be interesting to see how the prosecutors try to argue against this, because it's 7 pages of Bruce Harvey just explaining, in what world could a new judge take over this case. So prosecutors will respond on Friday, and then we'll have the hearing next Tuesday. But we were going to do a Melly trial update. I wanted to introduce you guys, and some of you guys may know him, but he's on Twitter as Bryson Boom Paul. You guys should check him out. He's been covering the Melly trial. He covered the first trial that ended in the mistrial, and he can give us an update on everything that's been going on with that, because I know Melly was in court recently and he got a new court date or a trial date for 2025, but there's still so much going on with it that I figured we'd bring Bryson in to tell us what's up. But Bryson, how's it going? Thanks so much for joining us.
What's going on? What's going on? Happy to be here.
You're the Melly guy. What are the chances that trial's actually going to happen in next October? There's an appeal going on, right?
Yeah. Actually, no. They're waiting on the appeal right now for the motions 1 through 13 that Judge Murphy originally decided on. And so the prosecution was like, well, we feel like you should change a lot of these rulings. So they're doing an appeal. But it's not going to be, I don't think, or necessarily it's not going to be in 2025 that the retrial starts. So after they finish the appeal process, I'm sure Melly's team will file a motion for a speedy trial, which has to be in 60 days. So it'll just start within that. So.
Gosh, so he's charged with 2 counts of first degree. Do they have the degrees in Florida? Is it first degree?
Yeah, it's first degree. First degree with a weapon.
And it's
first degree with a weapon. Yeah.
And it's for his 2 friends that he'd known for a long time and was
2 of his best friends. Yes.
Okay. And how many years ago was this? I know there's a lot of talk from his defense team.
The murder happened in 2018, and then he surrendered himself and been detained since 2019. So.
And no bail
since February. So the murders happened in October 2018, and then he surrendered himself in February 2019.
Okay. And the trial that happened was that last year? What month did
that start? It was last year. It was actually the trial. Yeah, it's been a year since the trial actually ended. Now it's been it ended on actually July 22nd.
And that was a trial,
It was
hung jury, right? They couldn't reach a verdict.
Yeah, it was a hung jury. It was a mistrial. So yeah.
Did jurors talk much afterward? I think
one did. One or two did, but the one that was the one that made the first couple statements was just the one that pretty much said she believed he was innocent and convinced 2 other people to change their votes.
So it was like a 9-3, 9 in favor of guilty, 3 not guilty.
Honestly, I don't think anybody knows the official number. Obviously, it was as soon as it was labeled a mistrial, like people came out with like different numbers, like 6-3, 9-2, and whatnot. But actually, nobody knows the number because the judge never gave it. So nobody knows the actual number because the judge never gave it.
Okay. Now it just seems like there's been so much extra stuff with this trial. It kind of reminds me of the YSL Young Thug trial. In that
Yeah.
We had a prosecutor change on it, right? The prosecutor was kicked off. The lead trial prosecutor, was she?
Yeah, Christine Bradley was removed from this trial, from the retrial. From the retrial. She was removed from the retrial as a potential witness now. So it's very highly likely that she will also take the stand in the retrial, honestly.
Interesting. And she was the prosecutor the whole time on the first trial. But
yeah.
What led to her removal? I know there's some question about
so pretty much they're saying that she and Detective Mark Moretti pretty much fabricated a couple things and made a couple moves outside of their jurisdiction, falsified information, falsified requests. Yeah, they had her for a lot. They pinned her for a lot. So, but the reason why she got removed is basically because the Judge Murphy was going to allow the defense to have her testify. So,
okay. And then the appeal is about the same. Is it the same judge, Judge Murphy, excluding?
No, the appeal process is in a whole different court. It's in the 4th District Circuit Court thing. So it's pretty much like the Supreme Court is handling the motions.
Okay. And is the appeal is about the same judge Murphy excluding?
It's about Judge Murphy's ruling on motions 1 through 13, which was like the cell phone footage or data, cell phone footage or stuff that was in these phones by respective people's phones. So he ruled on other motions too, like as far as using the documentary in the retrial and whatnot. So, but it's unsure what exactly the prosecution is trying to reverse as far as all 13 rulings. But I think the one they're trying to use the most, or the one they're trying to rule, or not but overrule, is the cell phone data.
And then the documentary footage I'd heard was something that he'd filmed. Was it like the night of the murders? They think that it places him at the scene.
Nah, it wasn't filmed the night of the murders. Actually, no, it was filmed. I mean, it was filmed in between all of that happening because the 2 guys are in the videos like early on and everything. They're doing everything all the way up until the very last part of the video where he has the disclaimer that says, like, his friends were shot and killed. So, but they're pretty much in the whole documentary.
Okay. So that appeal, you said of motions 1 through 13 is what's currently holding everything up, right?
Yeah. Yes. Is what's currently holding everything up until they begin a retrial process. So.
Okay.
But everything was as soon as the appeal went into play, the retrial was pretty much halted. So they couldn't do anything until then. So. And
he's the only defendant, right? There's nobody else
charged. No, YNW Bortland, his co-defendant is Cortland Henry, YNW Bortland. Okay. But they have so pretty much Melly and his co-defendant are involved in 4 different open cases right now. So they have 2 civil cases, and they have the murder case, and they have a wire tampering or witness tampering case. So
Okay.
that are open right now. So even after they get done with this murder retrial, they still have a witness tampering case that they have to go through, which if they are found convicted, they can get life in prison.
Okay. And is there any thought that those cases could proceed before Melly's, or is Melly definitely?
No, actually, I've spoken to the attorneys on all the cases, and they said that until the original cases are resolved, it's not really gonna move forward with the other cases. But the civil cases are like going through like the depositions and filing the documents and stuff like that right now, but they aren't planning on moving on with those until after the retrial.
Okay.
Or until they reach a resolution or reach a decision in his case, whether he's innocent or, found guilty. So, obviously, no matter how many times they have a mistrial, you can always go back. The state can always go back and retry them again. So as long as they keep having mistrials or hung juries, then they'll just keep trying them as many times as they want to.
Yeah. Gosh. Well, I mean, you've been covering the first trial. What was the interest like in Florida? He's been locked up for so long. What was his career like before that? It seems like it's kind of a classic case of he's become more famous while he's been in custody. He's sold more albums.
Actually, no. I think his wave never died down. I think the whole time, like he was pretty big, like going into all of this. Like before all this happened, he was on his way to being like literally one of the biggest artists in the world, period. And even me following the trial afterwards, I didn't realize his impact until while the trial was going on and how much of an impact he has on a global scale. But his even to this day, his streaming numbers have never dwindled past 10 million. His videos still get millions of views. His social media still has millions of followers. Everything about it, even though he hasn't touched or used his social platforms since being detained in 2019. So
wow,
it's amazing to see like the longevity of his career. So the fact that his fans are so devoted that even no matter what happens, they're still waiting for him to get through this and still willing to support him as heavy as they are. When most artists, like throughout my career in hip hop, I've seen most artists when they get jammed up by the law, usually that affects their sales, that affects their streams, that affects their popularity. But it's rare to see an artist like him and like a K-Flock and like Young Thug, even like their streaming numbers still maintain, their popularity still remains like they were fresh out yesterday. So
yeah. Well, I know Florida, where this case is being tried, has probably the best open record law in the country in terms of just access to court, public records. It's why we're able to see this live streamed. How do you cover a case like this? Are you just looking for court documents online? Have you made, contacts with the attorneys and stuff who kind of let you know about filings, or?
Both, actually. Yeah, now it's gotten to where I'll reach out to all the attorneys involved with the case. Obviously, the only people that I haven't gotten responses from were like the prosecution. That was the only ones I haven't gotten responses from. But everybody else, as far as the attorneys, have been pretty open about responding to my request for anything. But at the same time, I'm neutral to the whole thing. So I do wait until stuff is documented and filed and processed first before I even speak on it on social media or whatnot. So when I do talk to the attorneys, I sit there and talk to them with a neutral tone, like, hey, I'm just asking for clarification for this, or this is what was filed. I just want to get your response on this, and that's pretty much it. Like, I don't have a bias in the situation. So
yeah, you're not You're not stan journalism.
Nah, nah. I mean, I'm waiting on how to see this thing play out as much as anybody else. So I don't have a really I don't have to say that like I don't sit there and think about it like, okay, I think he did it or I think he didn't do it. I'm really sitting here like, okay, well, this is the justice system. So it's really like Melly could be sitting there like he could have had 18 cell phones on him at the same time. The night of the murders of his two best friends, everybody could have been around. It could have been at a full-blown rave or anything like that. Like millions of people could have saw it. And it all depends on what his attorneys present to a jury and as a jury decides. So
yeah. Well, how can people follow your coverage? Where should people go?
Twitter.
Yeah.
Basically follow me on Twitter, Bryson Boom Paul, obviously. Meghann, she covers a lot of other cases, but also make sure to find time to cover this case as well. So
no, definitely. I mean, if the trial, gosh, it's going to be a while, but if the trial ever gets going, definitely. But maybe we can get you on more later on if there's any updates on here, because I was thinking, there's just so many cases that it's good if we kind of pool our resources together, try to get like a virtual newsroom together.
I'm definitely looking into other cases as far as hip hop related. So it's, even though this takes up majority of the time, but it's a lot of cases that are going on in hip hop right now that I'm not more interested in following, but just equally interested in following at the same time. But a lot of times I have a respect for a lot of other journalists covering these trials at the same time. So if I see, like, say you covering like the Diddy stuff and like the ASAP Rocky stuff, I'll be like, oh, well, nah, just go follow Meghann. She has she's covering the trial at this time. She's the one on the beat and whatnot. So I usually have respect for other journalists doing it. And I'll just refer other people like, hey, I know y'all look at my coverage for stuff, but go check out this person. They're the ones like focused on this trial or focused on your favorite artist trial and whatnot. So like the ASAP Rocky coverage, like I'm sitting there following you like, okay, this is what's going on with ASAP Rocky right now. So yeah.
Well, yeah, there's been a lot of news on the rappers in trouble front lately. So So awesome. Well, let's stay in touch. We'll see if we can get you back on when there's some news, but it sounds like it's kind of slow going right now because of the appellate process. Nobody should expect anything.
Well, actually, a couple of people are just yesterday, one of the witnesses didn't show up, and his attorneys, Dontavious Weathers was the one that didn't show up, and his attorney filed a withdrawal from counsel like a couple hours after his scheduled deposition. So, and then they're saying like the person or the attorney John Phillips leading the civil cases is saying that a lot of the witnesses aren't being cooperative, aren't showing up to their scheduled depositions, and so I don't know. That's going to be interesting by itself. So
yeah, sounds like there's some trouble afoot then.
Yeah. Especially with them not responding back to their own attorneys. That's interesting. So
yeah. Gosh. Well, hey, thank you so much for taking a few minutes to fill us in. Everybody, check out Bryson Boom Paul on Twitter X and look for more updates from him on the Melly trial. So thank you so much, Bryson.
Hey, thanks, man. You too.
See ya. That's good. Yeah. Got to get the updates in there on all the cases. So I saw somebody saying that we're in the second hour of the live and asking if that's a record. I'm like, yeah, I think it is. I think this is the longest live that I've done on here. So yeah. Thank you guys so much for everything. Thank you so much. Yeah, Tori, I like your comment. Try to get rid of the fluff on everything. Just try to focus on the facts and get everything going. So breaking it down with B. Thanks for following. Thanks for following. Thanks for the subscriptions and everything. And yeah, I'm gonna I think we'll end it here, but there's going to be definitely more to talk about on Friday when the prosecutors file their response to all the defense motions, and then the defense should be filing their response to the prosecution motions, the request for the gag order, and then the request to limit supposed character evidence regarding Donovan Thomas, which is kind of the foundation for the defense's theory about Kenneth Copeland, because they're wanting to ask Kenneth Copeland about statements he'd made about things regarding Donovan Thomas, like people like he'd had assaulted or things like that. And this was with Judge Glanville. Glanville was saying there was no reason, or prosecutors were arguing to Glanville that there was no reason to bring this stuff up. And if I remember correctly, Glanville's ruling was that prosecutors could bring it up on cross-examination if they laid the right foundation. So this is prosecutors asking the new judge, Whitaker, to eliminate that. And then they've got the gag order requests. So all those will be pretty interesting here. So thank you guys for all the likes and everything on here. If you guys give me some more likes, it'll let the algorithm know that we're here. Give me a subscription. You guys will see me. My notifications come up when I'm going live. I'm going to try to get more consistent about a live date. Try to get some more people in here for interviews, kind of do a variety show like we did today. So, but definitely Friday, I think I'm going to be back on to update everybody about the opposition that will filed, all the responses that were filed. So we'll do another one on Friday. And then of course, Tuesday at 8:45 a.m. Eastern time, 5:45 a.m. We'll be back streaming the trial hearings that happened with Judge Whitaker. So stay tuned for that. So thank you guys so much for tuning in, and I will see you guys later. Thank you.